May it please,
Yes,
your Lordship.
all right.
Lordship, I beg to mention item 76, Lordship. This may not be taken up by your Lordship.
So and so learned counsel appearing for the petitioner has submitted. No, don't write all that. Is this matter before a bench without me?
After one week, Lordship. In the meantime, I will file affidavit.
When I'm saying before another bench, I will not say anything more.
Lordship, please.
Yes,
My
sir.
lord, item number 8, my lord.
8.
8, my lord. My lord, I have instructions not to press this petition, my lord.
Mr. N. Borua, learned counsel appearing for the petitioner has submitted that he is under instructions not to press this matter in the present form. Accordingly, this petition is closed.
Lordship, I am for the WMD department.
Is so and so
MD Vora,
the
Standing Council, WMD department.
standing council, as standing council. WMD.
MD.
My lord, I'm mentioning item number 82. This came up on 28th time and it did not reach. This is the 4th time in this fort. If it could be heard a little earlier. Your Lordship had advised us to mention this in the morning as well.
All right, 82 to side hobo. We'll try to take it up at 2.
Okay.
May I please, Lordship? I beg to item number 73 of today's list.
73.
Lordships. This matter may be adjourned for today, Lordships. As per my instruction, Lordship,
Why do we need an adjournment?
as per instruction of my client, Lordship, her grievance almost about to comply by the authority, Lordship. So
72.
73 Lordships. The matter may be kept
Don't
pending
appear.
some more days, Lordships.
Did not appear earlier. Why?
I could not take the instruction from the client, Lord. That is why, Lordship. Yesterday, I take the instruction, Lordship.
At the request of again after again on
After Chief Lordship.
3 weeks. That responsibility status quo almost complied. That is what you said.
Yeah, Lord, about to comply as
He's
per my
almost complied.
Yes. About to comply, Lordship. Yes.
May I please, your Lordship? Lordship, upon instructions from my client, I beg to withdraw item number 68, your Lordship.
So and so learned counsel appearing for the petitioner has submitted that he is in the instructions not to press this matter in the present form. Accordingly, the writ petition is closed. Yes, madam.
May it please your Lordship. Lordship, this is with regard to item number 78 on today's list.
78.
This matter has already become infructuous as my client has been promoted. In spite of mentioning on the last occasion, the matter is again listed today.
Learned counsel for the petitioner. Relief sought for in the writ petition has been granted by promoting that it is no longer requires of the above, the writ petition closed as in fact.
Much obliged.
May I please, your Lordship?
Yes, sir.
With the consent of others, my lord, I beg to mention item number 29 to 64, my lord.
Oh, yes.
And Lordship, some accommodation, my lord, in this
This was regarding,
transfer, my lord,
yes, all the transfer matters together, they've challenged
my lord,
those provisions.
my lord.
I am for the petitioner, my lord, in some of the cases, my lord.
And senior advocate also do is some of the cases, my lord. We have taken consent of
Taken the consent.
That on the part of my lord, Mr. J. Abidin, my lord, some urgency, my lord, in some cases.
Why, you have got a stay order in your favor.
my lord.
Not
You are not being transferred out.
all
What
the
is
cases,
the
my lord.
urgency? Huh?
Not in all the cases, my lord. Some
in
of
those
the-
cases where there is no status quo order, person had to go and join. What is the urgency? They are
Yes,
sitting down without joining.
illegalities-
Disciplinary proceeding, why not?
some illegalities taken place, my lord.
Huh? You could not get a stay order.
That already joined, that's why, my lord.
Already joined. They've joined.
Already- Yes, my lord, already
recorded.
joined, that's why, my lord.
I'll record that they've already
No,
joined.
no,
in
my
the
lord,
place of
some
placement.
of the cases, my lord. Some urgency on the part of Mr. J. Abidin, my lord.
Sir, give us a
That's-
date where we can. Give us a date, sir.
My lord,
Yes. my lord.
Your convenience.
detail urgency is no? Any date after 2 weeks, my lord.
Huh?
After 2 weeks, my lord, any date.
After 2 weeks, your data sucks. Huh? B. Talukdar, Learned Counsel, AP respondent, Education
Elementary,
Department.
my lord.
Education Department has submitted that he requires an accommodation in the matter to the Learned Counsels appearing for the petition in some of the cases, has submitted that there is urgency in the matter since their transfer orders were not given and were not kept in abeyance in the interim. So, this matters again on the 20th of February 2026. The Learned State requested to be prepared
My lord.
the next date with all relevant documents.
Obliged.
So this is interim protection in this series, that may be continued.
Interim protection operating in respective writ petitions continue the next date.
Obliged, my lord.
May I please? Yes, like to mention item number 16,
1-6.
16. In this matter, Lordship, actually,
Mr. Talukdar, Mr. Talukdar, a big hope taken away by you.
Obliged.
Series of hope. Yes.
in item number 16, in this matter, Lordship, actually, Dr. V. Ahmed,
Hmm.
he is conducting this matter, actually. He is not well, Lordship. He will come up after 3 weeks end date, otherwise we have to.
Submitted behalf of Dr. Ahmed that before this spot way, and therefore the matter may be fixed after
3 weeks.
3 weeks of episode data on 5th of March, on 5th of March 2026.
There is an interim order, it may be continued.
Frame order passed. It's a very simple case of a discipline. The
Yes,
punishment
next
has
date,
been enhanced.
Yes,
Is
yes,
it not?
yes, ma'am.
Don't you argue it?
But I have to discuss.
Prepare.
I'll do it next week.
Someday, somewhere you have to put in your foot. Argue it, is it?
No, actually, earlier it discussed with the Dr. V. Ahmed sir. If he is not able to, then I will argue this matter. Yes,
Prepare yourself. These are matters where perhaps we can have a discussion, bring it to a quietus.
yes,
Is it not?
yes, yes.
Lordship, I am for the respondent on behalf of SKMT. May I please?
If yours on behalf.
KKMT. May I
Yes,
please?
sir.
Item number 26, my lord. I'm going
20?
to file a rejoinder affidavit.
6.
Yes, I'm going to file a rejoinder affidavit today itself.
Ah.
It may be taken
From
up.
2023, you have not filed your rejoinder affidavit.
Yes, today I'm filing.
Huh?
Today
3
I'm
years down the line, how much more time?
I'm filing today, so any other day.
You'll file it today?
Yes.
We'll record it.
Yes.
Well, the counsel for the petitioner has submitted that he is in the process of filing the affidavit in reply to the affidavit in opposition. Today, it's accordingly. Is this matter again on? Huh? 13th of February 2026,
May it please, your lordship. Lordship, I beg to mention item number 80, lordship.
80.
80, lordship, lordship, hearing matter, lordship.
Ah.
Lordship, in this matter, I am respondent number 4 to 6 have filed their affidavit. So I will be grant some time to file my rejoinder.
When
I
did they
have
file the
taken-
affidavit?
On the last week, they have filed, lordship.
They have filed it on the 2nd of December 2025.
No, lordship, 27th of January, last week we have. Actually, they have filed 2 affidavits. Earlier it was, and
Second
this
one.
is the latest.
Not on record.
So I have taken consent from them, lordship.
Counsel appearing for the respondent, petitioner
Yes, lordship, I'm for petition.
submitted that they have received a copy of the affidavit of the additional affidavit filed by the respondents.
4 to 6, lordship.
Respondent number 4 to 6 full stop. He prays for an accommodation to file her response to him. Accordingly, list this matter on
After 3 weeks, lordship.
9th of March 2026.
Deeply, lordship.
Your lordship, may I please beg to mention supplementary item 83? And may I also please beg to state that may this matter be taken up with WPC 4736 of 2025?
What is the subject matter?
Your lordship, this is APSC related matters. In this writ petition, the petitioner was discharged
Who is appearing for the government,
from his service.
government in this? Uh-huh.
The petitioner was discharged from his service. So this writ petition.
We
is-
understand, we'll do one thing. The series matter is gone. So
Okay.
we can speed up the entire board now.
Okay,
We'll wait for the matter to reach. We'll
Okay,
see what
no
the
problem.
government has
Yes.
to say.
Yeah, yeah,
If
sure.
if it has to be taken up together, we'll send it.
okay, thank you.
May I please it, your lordship?
Yes,
Lordship regarding item number
Much obliged.
21.
21.
Yes, lordship, we have
Yes.
filed our affidavit today itself
Hmm.
and requesting to heart that affidavit with the
Have you-
original
have you
matter.
Taken the consent of the.
Lordship, they have not taken any concern from me. They have not informed me. On last occasion, Lordship wanted to dispose of the matter.
It is a
fixing-
very simple case where, sir, you are required to either allow or disallow the petitioner from making an option whether he wants to remain in CPF and he wants to go to GPF.
Yes,
You
lordship.
kept him under suspension during the
Regarding
period,
that, we have
maybe
received
rightly so,
something.
but he was never given the option. Right? So now he gives the option, he gives you back the CPF money, convert it to GPF. Is the usual procedure, grant him the pension or whatever benefits he has. And if you don't want to do it, we'll decide whether it should be done or not.
Today's fixed.
Last occasion, we were told that yes, it can be taken up today for disposals. If you
Okay.
want to file anything, file it.
Okay, lordship, then let the matter come up.
You file it, we'll call for the affidavit if required, we'll see what is your ground. It can be disposed, it will be disposed. If it requires an accommodation, we'll definitely accommodate it.
They have not informed me, Lordship, and mentioned with.
You are filing it today.
Yes.
Give her a copy now. Where is it?
They're mentioning
give-
at least they inform, they should inform us,
Come
Lordship.
back at 2.
Lordship,
Back at 2, let him file it, we'll call for it, we'll have it
at
at
2
2.
p.m. Lordship, deeply.
God bless.
Yes.
Application Lordship, I beg to mention item number 14, 1-4.
1-4.
Yes, English Council is out of the station. Lordship.
Let the matter reach, madam, it's a 2021 matter. We'll have to pass some order in it. We'll not dispose it, we'll not put you to a disadvantage.
English Council is out of the station.
We understand, we'll have to go through the file, see why we need to give a date. 2021, prior to 2023, we are not giving dates on mention. Don't worry, we'll not put you in trouble, I'm telling you.
Yes, sir.
Why are you worried? Go through the file, we'll see.
May I please, your Lordship?
Oh, yes.
I beg to mention for listing, your Lordship. Prolonged suspension, my Lord.
There is a senior bench, madam.
Obliged.
There is a senior bench, both for civil bench 2 and civil bench 3.
Right. Obliged.
In item one,
Yes, sir? Huh?
both the matters arising out of same as a
Yes, yes, we remember.
and Lordship, and it is search is submitted, Lordship, in both the cases. File CS number 1/26, 7/1/26. And POXO is also there, Lordship.
Huh?
POXO is also there, Lordship.
One of them has POXO.
No,
One of
both
the-
items in I don't know also why in item number 2, POXO is not added, not mentioned, but that is the same as
Where
others.
is the, what is the age of the victim? Yes, sir.
Lordship, as per last order, Lordship, we have taken step, Lordship, but in the office note, Lordship, it is not reflected that we have taken step because the
Ah.
office note is dated the Lordship 29, Lordship.
Hmm.
And we have taken step on 30, Lordship. So
On last,
We'll have to either wait for some time more.
Lordship, I have the receipt, Lordship. Taking step.
You have taken steps. We are not asking you to take steps again.
Yes, Lordship.
But whether served or not is something he has to be
Yes,
given a
Lordship.
copy of this.
And Lordship, if charge sheeted, Lordship, the scan copy of the trial court record along with the scan copy of the case diary may be
Call for
called.
that.
but in item number 2, Lordship, note as that POXO case number is not mentioned, that is a notice has not gone.
You are saying if it is arising out of the same FIR,
Lordship.
the same TCR will suffice or they'll have different TCRs?
No, same system, Lordship.
Then,
But notice has to go, Lordship, in both the cases, notice has to go.
you are talking of BS 69
Lordship,
or
69, Lordship. In cost title, POXO is not,
The order simply says case diary not received.
because Lordship, POXO is not mentioned in the cost title.
No, I'm not on that. What I'm saying is simply case diary is not received on the first order itself. In item 1, you take down BA number 196 of 2026 Spencer appears and submits that he has taken steps for service of this on the respondent number 2 on 30th of
30 Lordship.
30 January
Yes, Lordship.
2026. Stop. We learned APP has submitted that the matter has been charge sheeted. Full stop.
Right, CS number
Vice charge sheet number
1/26, dated 7/1/26.
on 2026. Call for the scanned copy of the trial court records along
Case diary.
his diary. Full stop. And and the steps have been stated to be taken as ordered earlier. And APP shall also have information on the status of the service of this. Yes. Placed again on.
On 16 or 17.
17th of February 2026. Item number 2. Yes, you are appearing, sir.
Lordship, I mean item number 2. The POXO is not added in this case, in particular to this applicant, this petitioner. As because
Why?
the police because they are concerned only with the suppression of their allegation is that they have suppressed the incident, the fact of the incident and misled the police. The POXO was not against them. POXO is only against the one Gautam Kolita, because at the time the girl was measured, and the main allegation is against one Jagat Singh, that is the father of the present petitioner, and not against this petitioner. And he was arrested as because he knowingly has suppressed the incident.
Some girl was kidnapped.
Some girl was kidnapped, she was killed, and she was put in a septic tank of a train by one Jagat Singh, that is the father of the petitioner. So thereafter,
Jagat Singh is the father of the petitioner.
yes, Lordship. The
Why
ground
is
of
the petitioner in problem?
Lordship,
He has suppressed what he knew.
that incident he has suppressed. So their ground of arrest is at page 3 or page 20 of the present petition. If stated,
That would also make him equally guilty of the
238 is section.
the ground of arrest of Jivan Singh, Sri, son of Jagat Singh, that the arrested
Where do you
accused
find that
person,
arrest memo?
Lordship, it is at page 20.
Who all were arrested?
Here by this for police forwarding, 3 persons were arrested.
Son, Rikibuddin, 4.
2 sons and one Gautam Kolita. One Gautam Kolita was also arrested. Kishan Singh and Jagat Singh are son. Rikibuddin Ahmed is a pharmacist, and another person was arrested. He was Gautam Kolita. Against him,
এজাহাৰখন থাকে নামটো সেই নদীখন যাব লাগিব এজাহাৰ থাকিলে তুমি পাৰ্ট কৰি ল'ব নোৱাৰা তাত আছে যাব লাগিব
the ground of arrest says
We'll have it listed along with the along with item number 1, because the CD and the TCR in that one has been called for.
yes, Lordship.
Is it not? I don't think the
even though Lordship he got the bail, suppose he got the protection from this, then also Lordship, if the cost title is not mentioning about the POXO in POXO case, in item number 2, then also there will be a problem. Because Lordship POXO, to my understanding, once POXO is there, Lordship, then we cannot separate whose involvement is what
we
extent.
can see it out here. But you are arrested in a case in which a provision of the POXO Act is involved. If you want to argue otherwise, we'll have to put it for argument whether the POXO has to be involved or not. Then we will decide what to do with the bail petition.
Yes,
You would be delaying the matter.
yes, Lordship.
Agree
Then
to,
I'll
have
take
an
steps.
agree to have an amended cost title file.
Yes, Lordship.
CD will be here on the next day. The informant would have been already informed about the pendency of the other case. We can ask her to address on this also.
Yes, Lordship.
Find out whether your bail can be considered or not.
Yes,
Will
Lord.
that not speed up matters?
Yes, Lordship.
Okay.
I'll amend the cause title.
We'll ask you to file an amended cost title.
Yes, Lordship.
Because otherwise you have to move an application that will take another 1 week.
Then I will take steps also on the informant.
But Mr. S. Tamuli, Learned Counsel appearing for the petitioner, the Learned APP has pointed out that the cost title of the case does not reflect the provisions of the POCSO Act, although in the FIR there are allegations of involvement of the sections of POCSO Act, full stop. Accordingly, to facilitate adjudication of the matter, Mr. Tamuli has requested to be allowed to file an amended cost title to incorporate the relevant sections of the POCSO Act which have been incorporated due to the allegations leveled in the FIR, although he makes a submission that the allegations against the present applicant does not involve the sections of the POCSO itself. Any commission of any act forbidden by the POCSO Act itself. That is a submission.
Yes, Lordship.
Mr. Tamuli is directed to file an amended cost title before the registry of this court, incorporating the relevant provisions which are incorporated in the FIR, full stop. The petitioners shall also ensure taking of steps for service of notice of this pending litigation to the respondent number 2 within a period of 3 days from today. Full
Yes,
stop. 3 days from today, in accordance with the prevalent notification, list this matter along with BA number 196 of 2026 on 17th of February 2026. The TCR and the scan copy of the TCR and the case diary have already been sought for in bail application number 196 of 2026.
Marvelous.
Yes.
Hello, sir. So actually direction was for paper publication. But Lordship, we have received the instruction from the petitioner that to strike out the concerned respondent also. So
Where is that application to strike down the concerned respondent?
we will be fully filing in Lordship.
And the counsel appearing for the petitioner has submitted that they may be accommodated for a week to allow them to file an application for striking out the names of some respondents who would not be necessary parties to the litigation. Full stop. The Learned Counsel appearing for the respondent number
Or 5.
for 5. And anybody? 1. You are the main person to object. He wants to strike out. You don't want him to strike out. Okay. The Swansea appears for the respondent number 1 does not object to the prayer for accommodation. Is the matter again on 19th of February, by which time the petitioner may file the application proposed, failing which the matter would be taken up for consideration on the materials available on record. We will not keep this hanging for much longer. Item 4. Implement of matter.
Yes, my lord. Only to
Yes, sir.
implicate party respondent, my lord.
Yes, sir. Any objection?
No. From my side, no objection.
Madam, no objection?
Yes, our administrative reforms, training, pension and public grievance. Pursuant to order dated 12/12/25. Phase 9.
12/10?
12/12/25, phase
What is
9,
that order?
second paragraph.
Hey, Harry. This is an application praying for impleading. Which one?
Some administrative reforms,
Where
training,
do we
pension.
find it? Where do we find it?
Yes, my lord. That is, I have stated in paragraph 2.
for implementing the Assam Administrative Reforms, comma, Training, Pension and Public Grievances Department to Joint Secretary.
Lordship?
To the Joint Secretary, he is to be represented by a Joint Secretary, the department.
I don't think so, because here only question is Director of Pension is required because
No, we are not on that.
But here, Honorable Court observed it.
Honorable Court observed on your submission, sir.
Yes, my lord, because my lord, the file what has been already sent in the hand of the said person concerned, my lord.
Karbi Anglong ne koi di. V20 January, Karbi Anglong.
Yes. Tell us, can a government department be represented by a Joint Secretary?
No, my lord, joint secretary, no, my lord.
No, then your prayer says that you want to implement the Joint Secretary.
Secretary, if secretary is done, it will be secretary.
The implement petition is wrong.
Thank you, petition.
Ah. For pleading the, he said, Administrative, Assam Administrative Reforms Training, Pension and Public Grievances Department as a party respondent number 10 in WPC number 7119 of 2025. Full stop. Learned councils appearing for the other for the opposite parties, namely the councils for the Karbi Anglong Autonomous Council, comma, the Accountant General Assam, comma, the Director of Pension, comma, and the Education Department do not object to the implement of the aforesaid department for proper adjudication of the matter. Full stop. Mr. Das, Learned Council appearing for the petitioner, has submitted that inadvertently the prayer clause requires the implement of the Joint Secretary. You take down the exact prayer, okay?
Page 70, my lord, in the writ petition.
Page?
Page 70 in the writ petition.
You take down from the page 6 of the 5, where I have marked by a pencil, huh? Full stop. Comma. The Assam Administrative Reforms Training, Pension and Public Grievances Department is to be represented by the Secretary of the Department, full stop. Accordingly, he praised that his Secretary, comma, the State of Assam, comma, through the Secretary, comma, Assam Administrative Reforms Training, Pension and Public Grievances Department may be arrayed as the respondent, may be implemented as respondent number 10. Full stop. The prayer made in the IS civil with the modification as prayed for by the Learned Council, the petitioner out, full stop, accordingly is allowed. Accordingly, the Secretary, Assam Administrative Reforms completed is directed to be implemented as respondent number 10 in WPC number 7119 of 2025. Interlocutory application disposed of writ conduct. By an order passed today in IA number so and so, this court has allowed the Secretary, comma, so and so department to be included as the respondent number 10 in the present writ petition. The petitioners shall furnish an amended cause title to the registry of this court incorporating the respondent number 10 as a party respondent in 3 days from today, and supply necessary copies to the Learned Council appearing for the other respondents. Who appears for the department, sir? You appear?
No, I don't.
You would appear, madam? Ms. So-and-so puts in appearance for the newly implemented respondent number 10, petitioner to serve a copy of the writ petition on so-and-so for onward transmission to the department. Full stop. List the matter again on 18th of February 2026, by which time 18th of March 2026, by which time all the respondents shall have their affidavits filed or their response filed to the writ petition. Full stop. In case time permits, the petitioner shall be at liberty to file their rejoinder in the meantime. This matter relates to what?
Bench 3.
Pension.
Yes, my lord, pension.
matter relates to pension, full stop, therefore, an attempt may be made on the basis of the pleadings to dispose of the matter on the next date fixed.
High level.
Kindly complete your pleadings. Yes, yes, sir, any instructions?
Yes, my lord, there is a direction for personal appearance also, my lord.
No, personal appearance only if
In fact, in the cause.
you do not have the this thing. Instructions, any instructions? Why? Who appears for the director, from the office of the director?
Directorate office.
Anybody appearing from the office of the director?
Yes, yes, my lord.
Yes.
Directorate.
Madam, this affidavit was not filed and you do not have a record of the affidavit not. That is what their instructions say. You are appearing for the government office, yes? It says that it came to the notice of this department only when the Director Elementary Education shared a letter addressed to the sending council wherein it stated that an affidavit in respect of 153 of 2017 had already been signed and shared in the year 2007. Seems there is a lack of communication and this case is pending.
Actually, they filed the affidavit on 8/5/2017. And there is a paragraph, my lord, your lordship go to it, para 7, my lord. That's why this is going on, my lord. Para 7. But the affidavit in operation. Got it?
Okay, then?
Para
7.
Para 7.
Yes, screening committee, that is what you are saying.
No, they say that they appeared, it is also stated the name of the petitioner appeared serial number 07522 in the state list, so and so, appointed during period 91 to so and so. In the state, after preliminary scanning application throughout the state, report has been sent to the government. Thereafter, government and further consult divisional scanning committee by operative so and so, examine the report preliminary the irregular so and so, ask the APA before the for verification of the particular to ascertain the genuineness of appointment. The case of the petitioner along with other were verified by the divisional scan with North Assam division and committee had furnished its report.
Did you participate before the divisional commissioner?
Yes, we have participate.
Do you have any documents to show?
Yes, my petition annex.
It is in the petition.
Yes.
Of your participation.
Participation. Page 30 and 29 is the in the translate copy notice. I was noticed.
Yes, please come forward.
After the cabinet approval was given in 2020, that cabinet approval decided to, accommodate teacher and tutor on the basis of the screening committee report. And as per the availability of the record, teachers were listed in list 1, tutors in list 2, and there is a category of teachers, the incumbents who were neither accommodated as teacher or tutor. So those incumbents who had appeared before the screening committee, their name should have been included in the list 3. But my lordship, we don't have any kind of record with regard to this particular applicant. The name is not
Cannot
visible.
be if there is a challan.
Yeah, that,
If there is a challan and if there is a notice issued to her,
right.
if she had cut out the challan.
An affidavit also stated that his name is appeared.
And this affidavit of
Affidavit,
Mr.
2007.
Katonier,
yes,
can you assist madam for some time to show her
Yes, yes.
where your director says that the name is there in the state list?
My lordship, this name is pertains to before the constitution of the screening committee.
But
But
our
after,
name cannot vanish from the screening committee.
yeah,
Can you do that?
of course not.
Then
But I'm speaking on basis of the availability of records. in the
records, yes, the
department.
screening committee records has her name at serial number so and so. Your director says so. Your director says so.
and
He
same
stated that the name of the petitioner appeared at serial number 07522 in the state list of irregular illegal teacher appointed from 1991 in the state, and after preliminary screening of applications throughout the state, the report had been sent to the government.
Yeah.
Do you have a copy of the report sent to the government, madam? Director's office.
We don't have to.
Do you have?
No. In the
Then how did you make the screenning? What was screened?
Yeah, the screening committee was done under the guidance of the divisional commissioners. And the reports that were furnished to the department from the divisional commissioner, these were the teacher verification forms. My lordship, we generally examine the teacher verification forms. But that teacher for verification form pertaining to this petitioner is not available in the
Then what was available in serial number 07522?
That's
What was available, madam?
so that would be like director elementary.
We today, if you tell us court number so and so, we'll hear the matter on court number so and so. You are not going to hear to us. The Guwahati High Court does it. The education department does it. We have both of you together here just to show the confusion between the two hierarchies. This will not be allowed. When do you want it next fixed? Where the director of elementary education would tell us how this number came here. From which list? And you would tell us how did you prepare the list 1 and list 2? Where are the two lists? And where is the third list? The people who were not recommended here, the people who were not recommended there. The people, there were 3 categories. Those who had the qualification.
Those who have received the salary.
Those who have received salary even for 1 day. Any person who has received salary for a day is to be accommodated in either of the two.
Exactly.
Right.
And those who have not received salary even for a single day, you took them as illegal teachers. They just had their names, and because they were not against any particular post, no salary was ever given to them. They are just holding appointment letters and nothing. That was
Yes.
the basic. But here we have a number. And this assertion that she has received a salary for a month.
Yes,
Where is that,
because of that same select list, all are receiving salary along, including me also.
How do we say that you received the salary?
Yes,
Was there a salary slip? Was there a payment to the bank? Is there a, we used to sign those big salary registers saying that yes, today
Yes,
the
madam.
salary has been something?
Yes, after my lord, I was appointed in 8/3/2001. And thereafter, my lord, what happens on the basis of selection, I was appointed. I am receiving salary. I am receiving salary till my lord 2006. In the meantime, what happened? I am.
Show us one of the documents which shows that you
page,
received the salary.
Page 18.
18.
18. Sorry, 17, my lord. 17. As per interim order passed so and so Honorable Guwahati in pursuant to the Principal Secretary Government of Assam Education Department Dispur Elementary so and so Ranjita Dega working against retirement allowed to draw her salary working period until further order.
Madam, you would perhaps require to take notes because you would not go through the writ petition. You would not have a copy of the writ petition.
Well, the problem is that main crux of the problem is that I am receiving salary regularly. What happened? In the meantime, I was married to at the Lakhimpur to Bipuria. I filed an application. I am preparing for transfer me into Lakhimpur to Bipuria. I was, on the basis of that, I was transferred page 18 by the DI North Lakhimpur, I was transferred to B Puria and join in my place. From that onwards, my salary was stopped. This is the crux of the issue. Page 18. Your Lordship, as per proposal, Block Elementary Education Officer Srimoti, Srimoti Ranjita Borpatto, Assistant Teacher number so-and-so, is hereby transferred to.
We are doing the case in front of you so that you understand the facts and we can actually come up with some solution this way or that way. Mr. Talukdar, kindly allow them to have a seat also, if can be arranged from behind. Mr. Khatonia, we request you kindly allow them to have a look at the
Yes, my lord.
writ petition.
Writ petition. I have a copy, my lord.
So that when we are discussing the matter, they would also go through it and they will come up with specific instructions, different levels. Since you are trying to differentiate the levels of the director doesn't do it and the secretary is not informing us, we'll have both of you listen to it. And we'll have instructions from both of you. This will not go any further. Yes.
Yes, please make kindly say.
So
Page
let us
18.
see. You say by page 16,
Yes,
you were appointed on 8/3/2001.
my lord, on the basis of selection, my lord.
On
Whatever.
whichever way you were appointed.
And
You
thereafter,
were
my lord,
appointed on 8/3/2001.
my lord, thereafter, my lord,
Then
ours.
there was a writ petition 4280 and 4891 of 2001.
Yes, my lord.
Now, can we have a look at that order? Do you have the
No,
copies of the
there
order?
is some other petitioner.
Okay, heard Mr. N. Bora, Learned Counsel appearing for the petitioner. Mr. Bora has assured the court that he would produce the copies of the orders dated of the order dated 26/6/2001 passed in WPC 4280 of 2001 and WPC 4891 of 2001 on the next date fixed, full stop. Now you stop writing. Yes.
Actually, petitioner was not filing writ petition. Other same similar situated person was filed in that state of Assam. So the direction was given that particular those who were appointed in OBB, my lord, that my lord. And thereafter their salary was directed
Were you appointed under the OBB?
Yes, initially appointed in the OBB.
Mr. Bora, again, if we don't have those materials before us.
No, I am not on that. And thereafter page 18, my lord. Thereafter I was receiving salary
Thereafter
regularly.
page 17.
Yes, my lord.
Thereafter, okay, now page 17. There was an order of the Principal Secretary to the Government of Assam. There is an order number.
Yes, my lord.
ELC COP so-and-so dated 28/9/2022 and Director of Elementary Education Assam. Madam, can you take note of both of them? Both of the orders, the order of the director. The Learned Counsel for the respondents shall also produce copies of the order bearing number ELC/COP within bracket C 383/2001/117-A 11. Sorry, I gave you the wrong number. ELC COPC 383/2001/179/79 dated 28/9/2002 issued by the Principal Secretary to the Government of Assam Education Department and the order dated 16/11/2002 bearing number EHA/392/2001/117-A issued by the Office of the Director of Elementary Education Assam and a copy of the order bearing memo number 7934-8167 dated 17/12/2002 issued by the Office of the Deputy Inspector of Schools, North Lakhimpur. Stop. The Learned Counsel for the petitioner submits that it was pursuant to these orders. Now, that these orders would reflect that the petitioner was allowed to draw her salary for the working period, which when she had rendered her services after her initial appointment on 8/3 2001.
My lord.
That is it?
Yes.
The learned counsel for the petitioner has further submitted that the petitioner had prayed for a transfer for consideration for transfer from Lakhimpur to Bipuria. And pursuant to the said application, a transfer was allowed by the order dated 22/2006 issued by the Office of the Deputy of Schools, North Lakhimpur.
And thereafter join on text.
And she joined there on 23/2006. Then
Thereafter my salary was stopped.
who is this Dipennath on the next page?
The next page, I come before the Honorable Court. My
Who?
name is.
Who came?
I along with my similar situated person.
Serial number?
Serial number 6.
The petitioner thereafter approached this court in WPC number 3459 of 2009, where her name appears at serial number 6. Full stop. In the said writ petition, the petitioner, this court had noted that the petitioner's name be, that the petitioners were to make an appropriate representation to the Director of Elementary Education, who would then refer the claims of the petitioner to the committee constituted under orders of this court passed in the matter of Sudhendu Mohan Talukdar versus State of Assam, reported in 2006 within bracket 2 GLT 216. Full stop.
After notice was issued by.
Notice was issued by the District Elementary Education Officer Lakhimpur to the petitioner on requiring her to appear before the committee on 19/12/2014 from a Friday.
Friday at Circuit House, North Lakhimpur.
At the Circuit House, Uttar Lakhimpur. The petitioner had also submitted challan
of rupees 100.
Of rupees 100 as required, which is dated 10/2/2012. Letter.
This is the report, my lord, by the Commissioner North Assam Division. There are 2 categories of teacher. That's why I am verification report in respect to 19.
Madam, if you have page 32 for a moment. Page 32. This is from the Commissioner to the Additional Chief Secretary of the Government of Assam. Annexure G, is it? It never went to the office of the director, it went to the office of the government.
Because, my lord, this screening committee was looked after by the government only. That is the reason, my lord.
So it went to the it went to the government, so
Yes,
it will
my
be available with the government.
Yes, my lord. Lakhimpur, not Assam district.
And there is certificate issued by the
Initially,
master on
Dhemali appointment.
15, 19, 12, 16 and page 39. She was, everything is there, my lord. It is hereby certified that so and so, so and so, so and so appointed assistant teacher, so and so, so and so. On so and so, 22/2006, she was transferred from said school 216, so and so, so against a retired vacant post of.
We'll come to that. So this is a document, this report was sent to the governments. It should be somewhere available.
But page 32 in respect of Dhemali district, my lord.
Huh?
Page 32.
We are reading page 32.
It is in respect of Dhemali district.
You are from which district?
She is from Lakhimpur district, my lord.
Okay. Yes, sir, what do you say? This is Dhemaji, not Lakhimpur.
Dhemaji, my lord, but all are in North Assam division test for entire, my lord. Not
Unless you show us that We are trying to sort out the problem to the benefit of both the parties.
Both the parties.
Let them have all the records, let them trace out the records.
Right.
If you are giving a wrong letter,
And this is the, I
then we
think,
cannot give the letter.
I am, so I am not going to.
Then the screening committee will drop the issue. Unless we trace out the screening committee report, which was based on the divisional
This
commissioner's
is the report, all reports, reference,
No.
report verification, my lord. This is the Commissioner, North Assam Division, Tezpur, entire, my lord, Dhemaji, Lakhimpur, so all are, my lord, verified.
Mr. Bora,
My lord.
we are asking them to produce particular letter numbers with particular dates.
My lord.
This particular letter
My lord.
will not lead to your case.
Okay, my lord.
Understand the difference?
Not
The
necessary.
moment we do not give emphasis to this,
Hmm.
the screening committee, whether it contained your name or not, which is the ground taken by the department to not to give you the present salary or regularize or whatever you are paying. We will not be able to adjudicate that. It has to go before some other authority. That is the situation. It will be a tell exercise what we are trying to do. If we can trace out that divisional commissioner's report.
No, we are not on that. My problem
what?
is that on the basis of the honorable, there is a specific, admitted that there is a specific direction from the honorable court. It is the admitted that I'm appear, they given the notice to me. It is the admitted that I am also given the 100 rupees, my lord. And I am appeared, I am stated, specifically stated by environment, I am prepared before the. And they have filed an affidavit stating that my name is appeared, serial number so and so.
How could the director do it? The document was not even referred to the director.
I mean, I don't know regarding that whether this is their internal documents. I cannot say because of that. My name is not there in that letter, my lord. But my specific instruction that as well as the certificate by headmaster, due to my marriage, I transferred to the place, one place to another.
No,
My
who's
salary
Rafika
was
Begum on the next page?
Huh?
Page 33, who is Rafika Begum?
That is, my lord, I am praying at that moment, my lord, that's praying for direction to petitioner appear with a commissioner so and so would be and for my lord, verification why they are not given. So there but this order has been passed in other writ petition. So I'm not on that. Now, my lord, there's a specific certificate is there that I was working and due to my marriage, I was applied before the competent authority. They transferred me, thereby my salary was stopped from that onwards. Until today, I am working, but without any salary, my lord. And
This Rafika Begum is not helping
No,
you in any manner. It is neither here nor
that
Yes, now we will require only two things. Your screening committee, your non-screening committee, since you are not being able to produce the records, those records have to be produced if you have them. Otherwise, tell us how you dispute his appointment, not the mode of his appointment. It was illegal, irregular, we are not listening to it. Tell us, once he was appointed, there was a court case in the year 2000. He approached this court.
2002.
The decision was
2001, my lord.
2001. Thereafter, there is a letter saying that you gave an order asking salaries to be released to her. Now, at this point of stage, if she has been working, how do we deny her the salaries? Yes, Ornima Chetia and whatnot. One of the biggest fights we tried to put up. Yes,
The headmaster had given a
certificate. If he's stating the wrong thing, dismiss him, terminate him, hold a departmental proceeding. You are not doing that. Headmaster is a good person. Cannot be allowed to remain so. And if it's the wrong certificate, that is what you do. If you're not disputing the certificate, give people a chance to eat bread and butter, is it not? Wrongly working, ask her not to work. Howl up the headmaster. He must have retired and gone. There is a present headmaster.
only two teachers is there in the particular school. Without her, my lord, cannot be run. This is happening, my lord.
If this is what is required to be done in each case, whereas salary is being asked, we'll do it. We'll do it. We'll say on this particular case, what your divisional screening committee, what your other committees are not being able to do. We would do it. We'll reject who is required to be rejected. We'll allow who's allowed to be, who's required to be allowed. And we'll have all the records here. Persons conversant with the records. Because the statement that you made today, that you are on the basis of records which are available, that means you are not conversant. That would require the secretary to be here because our order said a person who was conversant. If a conversant person is not coming, how can we help you? You are giving all the leverages we can. The instruction which is now here, what does it say? It says, in this regard, it may be mentioned that this department has taken steps. Your very first sentence, which says that our name is not there on the record, your director says, no. Serial number 075, whatever. So that you have a copy of that document which shows her name. That serial number so and so. Then why are you here in the court? The next line we are going to record is that the persons appearing before the court is not conversant with the facts of the case. You cannot be conversant with the situation. Illegal, irregular teacher, I am very conversant. You cannot be that. We are dealing with a particular petition. When can you be conversant with it? Who will come who is conversant with it? Tell us. Discuss with them. We'll give you 15 minutes. Who's the person who can tell us?
Yes, my lord.
Without creating this chaos in the court. We'll sort it out today. And today it is. When do you want it? What time?
After 15 to 20 minutes.
In 20 minutes, tell us who will tell us particularly about this case. When the director says the lady is there in the serial number so and so, and the commissioner says her name is not in the list. And she is serving, headmaster says she is serving, EIS says she is transferred, allowed to join. Another person says yes, joined in my presence. And then we say no, no salary. Can it be? Can it be?
At 12:15, my lord. Obliged.
Itu half order to থাকিব.
It.
You are here till 12:15, Mr. Bhatt. You'll be here at 12:15. Yes.
One case is there.
Yes, sir.
Well, Lord, this case, yesterday with the old case, I have taken instruction from him night only. They are saying that their forms have been accepted and verification was done. And they had been said that they will do some needful. In this regard, my lord, on 30th for 2025, our learned friend has submitted prayed before is unable to file affidavit. But very next day, due to my health reason, my colleague has taken time. Now, if affidavit is filed, on instruction also received this, if our instruction may be wrong or this one, because also I'm depending upon their telephonic version. I said that can be decided proper way if my learned friends take instruction from this.
My lord.
Otherwise, what?
My lord, because my lord, I would like to submit on the basis of the pleadings made in the writ petition, my lord. So affidavit is not necessary because they are claiming the benefits under Upenda's case, my lord. But that benefit cannot be granted to them. They cannot claim, my lord, because they are seasonal workers, my lord. They are not continuously serving in the department, my lord. Seasonal worker, DDT.
Do they have any appointment letters?
No, my lord.
Huh? They must have something in the department. Some introduction to the department.
Yes, my lord.
What was that mode?
Working certificates are there, my lord. They have produced.
It better if my submission is this one. If learned friend wants to go for
And that
hearing.
certificate also says that they are a seasonal DDT spray worker.
Yes, I do agree on that point. My judicial order is there to file affidavit in opposition. If my learned friend not inclining to file, okay, this may be clear, then next date maybe so that I can take some support.
That was cleared so long ago.
No, that's all right. Lord,
That was cleared so long ago.
Yes.
Mr. So-and-so submits he is permitted to argue even in the absence of an affidavit in opposition. He has made his position clear
Here Lordship will see.
4 years ago.
Let's tell it. Lordship may produce then 34 series.
Page
30th April of 2025. Lordship got. 30th 4. Listening
You
Council
took
decision
time.
said that
Secretary
further
from
time
the
is
earlier
required to
stand, you
obtain
took time.
instruction to file
Giving them
affidavit.
some hope of
This
filing a rejoinder affidavit.
My lord, what, because the position is clear, even the finance
I
department,
understand, but why
finance
did-
department is also there.
But
my
you
lord.
have taken time on 34-2025 and Mr. Burwa is feeling very uncomfortable arguing without knowing what you have on a document.
Yes.
Yes, my lord.
You
This
can
is
give him
only.
that much of leverage.
Yes.
You can give him that much of leverage.
Hmm?
Write down 2 sentences. On the basis of the admitted facts in the writ petition, the writ petitioners are not entitled to the relief called for in this petition. Submissions will be made at the time of argument. Deponent identified by seal given.
Yes, my lord, I'll file,
Yes.
my lord. I'll file an affidavit.
Reply to that 2 lines, it will be longer.
The reply would be longer.
Longer.
Yes, my lord.
He wants something in writing so that he can.
Because this is
lord.
way poor people are, my lord.
Yes, my lord.
We can,
After
by,
4 weeks, my lord.
Because somewhere we have seen some draftings in appeals which says even before the department could answer, my case was dismissed.
I could have got it, but this
So,
very.
because you had made a prayer on 34-2025.
Yes, my lord, I'll file, my lord. Yes, my lord, I'll file a
I
sort.
think Mr. Borpujai's affidavit would be shorter. On the basis of the affidavit filed by the health department, finance says no comments, no comments, no comments.
Since, my lord, he is the employer, now the nature of service can be very well spelled out in his affidavit. That will clinch the issue.
Here
Yes, my
only-
lord, so far as putting the dictum in open dust, then that we can argue on the law point.
What he says it is seasonal.
Yes, my lord.
Says it is seasonal.
Otherwise, prima facie Upendas is not applicable in the case for the simple reason that in Upendas case, the issue that was decided is with regard to, my lord, the master role and workers who are working in works department. For the case arising out of PWD and other ancillary departments. So here is a case where they are not doing that nature of works. The vast difference between seasonal worker, casual worker. Anyway, my lord.
I'll reply to that.
Yes.
I have reply into this
Yes.
point. I'll reply.
So
If
once
let-
you
let
give it in
come.
writing, then he will give it the report.
Yes,
Yes, my lord.
because I'll show
Otherwise,
document.
2018 matter. So you are being treated as a reserved force.
Yes, my lord.
Reserve force, we are treating as a reserve force whenever it is required. What happened thereafter, now fresh,
So if
they have double
penalties is to be applied, you will be paid salaries for the time you are put in reserve.
problem, that is correct. That was point up to this. But what happened, this development has occurred due to the department has developed us. Because form was sought for. Accordingly, these forms are not supplied to me, other this one. Then I approached this honorable court, in short I'm telling. This honorable court interpreted the matter. Now, yesterday, if my submission, basing on my client submission, if already form verification is done, they're going to this one. If so, then if today case is gone off means without affidavit, definitely my case will go off. If at all they want to this one, let latest instruction can bring me not.
The form fill-upping part may not be due to the
No,
be the
my lord, that's
consideration
correct.
for your
That is-
appointment.
but what happened, I also
different reasons.
I also represent this some downtrodden people, my lord.
Mr. C. Bora, Learned Counsel, appearing for the petitioner, has submitted that the affidavit in opposition has not yet been filed, and he would not be in a position to argue unless the stand of the respondents are made known to him in the form of an affidavit in opposition. The grounds of resistance by the respondents are made known through an affidavit in opposition. Although Mr. D.P. Bora, Learned Counsel, appearing for the Health Department, has submitted that on the basis of the materials available on record, the matter can be argued, comma. He has sought for 2 weeks accommodation to file a short affidavit in opposition to the grounds taken in the writ petition. Mr. Arbor Pujari, Learned Counsel appearing for the Finance Department, has submitted that applicability or otherwise of the decision of this court in Upen Das is a point of law and would be argued by him at the time of hearing, full stop. The DP list this matter again on Tini Hoptaman.
After 4 weeks, my lord.
4 weeks. 23rd of March 2026.
Yes, ma'am.
By which time it is expected that the health department would have their affidavit brought on record. The petitioners would also be at liberty to file their response. Since the matter is of 2018 and relates to the benefits of the of 2018, full stop, it is made clear that the matter would not be would be taken up for consideration on 23rd of March 2026. Stop learned counsels are requested to be prepared for a disposal.
Obliged, my lord.
Obliged.
I did Mr. Bora give some advantage to.
Yes, my lord.
They are already at a disadvantage.
Yes.
You are saying that it is seasonal. Disadvantage them further. Yes, 7.
Lordship, in this case, I have received the instructions,
Ah.
Lordship, I want to file affidavit, Lordship.
What was the matter about?
Media matter to me.
These old matters. What is the matter about, sir?
First question is maybe. It is he is a doctor, Lordship, and he studies under the Assam Medical State Health Quota. In State Health Quota, he is studying PG course, PG diploma in gynecology. And the condition is that he should
You wanted to resign.
resign. He should
Your resignation is not being accepted.
not accepted.
Even after the 8 years have passed.
No, Lordship, he do not complete the 10 years.
No. When did you not complete 10 years?
It is page 26, Lordship, it is clearly written.
You had joined the post in 26/9/2016.
As per bond agreement, he has to complete 10 years of service.
You have joined services on 26/9/2016, not
16.
disputed.
Lordship. And also he resigned in 18.
You wanted to resign from the services without paying the money that was required to be paid.
It is the case.
You have served. You have how many months left now? How many months of service left now?
1 year.
8 years? 8
1 year,
months?
8 months.
8 months. Why 1 year?
Is from
Your
Hailakandi
10 years,
district.
your 10 years complete into 2026
10 years.
will be complete. This is 2026.
And now
February, March, April, May, June, July, August, September, October, November.
He is not continuing.
not continue. After resign, he is not continuing. Court has got given stay order.
He submit the application only.
What has been stayed? Not take any coercive action. What coercive action can?
The resignation, his license may be exempted or something.
Where is that?
No, not lot.
Where is that term? Where is that condition that your license may be exempted?
No, it is not. I am saying, due to afraid of this, he come to this court and court has given.
What is the solution that we can give?
Condition is that it is in.
What is your prayer? It is not possible to post him anywhere in Hailakandi or
Majuli.
Anywhere within Hojai.
No,
It is
Lordship.
not possible.
Terms and conditions for 10 years cannot be, Lordship.
Let us understand it this way. He is saying post me in Hojai or accept my resignation. Are you understanding what we are saying? What his prayer is? It is not possible to let him resign prior to 10 years of service. Under orders of this court, you have not taken any coercive action. He is not serving you anywhere now. He is not serving you here. He has not joined his duties after giving the resignation letter.
Yes.
If he is posted in Hojai, his ground of resignation goes, he is forced to work with you. Is it not?
But Lordship,
You get
as
10 years of.
terms and conditions of the bond agreement, Lordship, if he cannot continue 10 years, then he have to pay compensation 25 lakhs. That is the rule.
A person joins a service after completing his studies. He does work for 1 year. Then he cannot work. Where will he get 25 lakhs from?
But Lordship, from 2008, he is servicing, Lordship.
He's serving
He's
since
MB
2008.
MBBS.
So it should have been accepted in 2018.
In 2008, he is in MBBS. In MBBS service, he is also completed, and also 2016, he has got PG.
Huh.
Then what?
Your bond is after your PG,
PG.
not prior to
Yes.
PG. Yes.
Before PG, Lordship. After
Where is the bond?
MBBS, after
Where is the
M-
bond?
Bond is
there is no
24
bond.
page.
Bond
Huh?
he has not.
Where is the bond?
26, Lordship. A bond is not written. Condition is here, Lordship.
Where
Bond
is it? Page 20?
26, Lordship.
Para?
Condition is there.
Para?
Lordship, C. After the second round. After existing clause 5, the following shall be inserted, namely 6, clause 6, out of the said 17 diploma seat of the state quota under clause 1(3), seats of the subject of anthropology.
You
B,
give back your PG degree then. You give back your PG diploma degree.
Yes.
You took the seat saying, I will go and serve in Majuli and Hailakandi. Now you say, please, I cannot serve there. Pay the 20 lakhs, you're dismissing.
That is why. Let me file my affidavit,
We
Lordship.
are dismissing it.
Lordship.
Still affidavit. Yes, tell us. Is it only compassion you are here before this court? Why cannot you go?
Lordship, due to father and mother is also very ill in.
Your father is still alive?
No.
Gone. So that ground is gone. Next.
Mother is also there, Lordship.
Carry your mother to Majuli. It's now far better from
Give me
2016.
transfer, Lordship. I am seeking transfer. They do not give me. Also, they.
No transfer. You cannot ask them to transfer. You are just keeping, how are you living now? What is your mode of employment now?
Now working in nursing home, Lordship.
Where?
Nursing home is good.
In Hujai, Lordship. Hujai.
Your PG degree.
He's in residence is Hujai, Lordship.
With your PG degree. Is a specialist.
No.
Oh, all fingers in butter. जीत में जीता पर तुम हारा.
He is agreed to give.
जीत में जीत गया पर तुम हार गया. गवर्नमेंट को बोल दिया. I'll take the PG diploma. I'll take the PG degree by saying I'll serve in Majuli. Then I'll approach the court for the last 10 years. I will keep practicing in Hojai. I'll keep making the money, and yet I'm not picking up the 25 lakhs. When can you pay up the 25 lakhs?
Lordship, kindly see my resignation, Lordship.
We'll allow them to accept your resignation, pay up the 25 lakhs.
I am also I have bound to pay the rupees, Lordship.
You'll pay it. Now you'll pay the 25 lakhs. Allow him to resign.
Yes.
That is discussed.
When will you pay?
Between 1 month.
Huh?
1 month.
25 lakhs and the resignation that will be done.
Yes.
Have your instructions?
That instructions.
You
That-
can ask your department, he is ready to pay the 25 lakhs.
Yes.
Accept his resignation now. As of today, accept it, 25 lakhs. He has not completed his 10 years. Is it not? Otherwise, what would have happened? See, if he worked for you 9 years, then he resigns. He still pays you 25 lakhs. Out of the salary that he got for the 9 years, he will keep saving little, and he'll pay you 25 lakhs and he'll go on the 9th year. Now he has not worked for you. You have not paid him anything. He has earned somewhere else. He'll pay you the 25 lakhs now. Finish the case.
Lordship.
You need 25 lakhs. Then you cannot stop him. He's ready to pay within a month.
Within a month.
Let him pay the 25 lakhs.
Yes, Lordship.
No need, Lordship. I
No
just
need?
want to pay.
Huh?
I will pay, Lordship.
You,
In
from the
my
date of your,
resolution, I also clearly written, I will only mention, sir, I bound to
where?
bound by the bond rupees 25 lakhs should
Where are you?
Annex.
Where is it?
46, Lordship.
Page 40?
6.
Ah,
Third paragraph, Lordship.
oh, nothing this case. Huh?
I will be wetly to mention here that, sir, I am bound by the bond rupees
Hmm.
25 towards government and personal family professional.
Hmm.
I ready to pay, Lordship.
When did you file it?
22/4/18.
Huh?
22/4/2018.
Ah. Where is that again? Yes. The bond, yes. Where is appendix 2? Do you have a copy of this page 28? This agreement which they are required to sign?
Page 26, Lordship, it is the guideline.
Expenses, where is the guideline? No, 28, you have given half the document.
Lordship, it is the
That
Some
appendix to
medical-
deed of agreement, we want to read that. Do you have it with you?
agreement is in their
That I
custody,
have to
Lordship.
obtain from
This
the
is a sample,
principal.
the sample, do you have it with you?
They do not give.
Where did you get this? The Assam Gazette. Gazette notification.
Agreement.
Madam, kindly find out. We'll take up the matter at 2. Yes.
In this case, agreement is not here, but another case, in another case,
Ah.
that agreement,
So when he's paying you the 25 lakhs, what is your objection? That is what we want to know.
we have no objection. This is the bond agreement is as per the bond agreement here.
So he pays you the money, you are ready to
Yeah.
release him.
If he is not continuing.
Oh, your prayer is by relaxing or waiving the bond. That is why the matter has been pending for. Now, you were agreeable to pay 25 lakhs in 2018. Rest on that to the government. You paid it that point of time. Madam, kindly have your instructions at 2. He will pay the 25 lakhs and you will accept the resignation. Can it be done? The bond is for 25 lakhs.
25 lakhs.
Take the 25 lakhs, let him go.
Yes.
His prayer in the writ petition was, I will not pay the 25 lakhs.
In that regard, I talked to the officer lordship,
Ah.
but they said that the matter is 2018, the record is not found.
We do not need the record. Admitted position, he is working. with
Yes,
you.
yes, lordship, I will.
Admitted position, he has given you a resignation. Admitted position is 25 lakhs, he is ready to pay as
Pay.
of today.
As of today.
He will pay it within a month, we will list it after a month. He pays you the check. You take the money, release him. He does not pay the check. We will say his resignation can be accepted only when he pays the money. And if he has not worked and is using the degree, since he is not paying the money, he will not use the degree for the next 10 years. We'll stop the use of the PG degree because it was taken by unfair means.
Yes, Lord.
He will not use it for the next 10 years. Thereafter, he will again use it. He's agreeable, see. At 2, just talk to them.
At 2, lordship.
At 2, only we need to know whether 25 lakhs and he can be released. Have your concrete instructions. আহিলে দিব।
Here, my lord, I am praying for lordship accommodation, my lord, to allow me to file my affidavit, finance, my lord. I'm seeking 3 weeks time, my lord. We have already received the instruction. Somehow it was not filed.
We'll allow you the time at 2. None appeared in the last occasion.
My lord,
None here at 2.
my lord, my lord. I'm so glad.
Yes.
Affidavit has been sent for vetting, lordship. Mr. D. Upamanu is appearing in this case, lordship, but he is on lakes in another court, lordship.
Sorry?
D. Upamanu. So he requested me to obtain this.
Kindly,
I
the
think it's a very small
last order, Lord.
issue.
23/4/2025.
Where is your termination order? Is your termination order?
Lordship, page number 22.
Then lordship may take it up at 2 o'clock. I will inform the council, Upamanu. That will be better,
We'll grant
lordship,
you the time
because
once we go through the.
I am not aware of the fact.
Lordship, this is the common termination order. We have appointed in 2008, Lordship. Thereafter continue service. Then suddenly, without any reason, they have terminated us. That said that these are illegal appointments.
The health services.
Yes,
Joint
health
actor.
services. Yes,
Joint
no
actor
doubt.
appointed you.
Page number 11 is the appointment.
Huh?
11, page number 11.
Joint actor appointed you.
Yes. Some of the appointment, Lordship, is grade 3 appointments are fake, some of the appointment. But in respect of grade 4 employee, there is no fake appointment. And some order also I have annexed, all the grade 4 employee get the release, Lordship. The similar order I have annexed, Lordship.
You did not approach the court at that point of time.
No, at that point
Why?
I have not.
Because you did not know the termination was there.
Yes.
Did not know because why? You are not there in service.
So they
You
know,
were not
Lordship,
attending office. Everybody knew you did not know.
if the grade 4 employee,
You did not know that you were terminated.
he know, Lordship, but the reason he have stated that.
You
He
did
has
not get
stated
salaries
the
for 2
reason.
years. You did not know. You have to kindly ask him to.
Lordship. Obliged, lordship. Give me answer. What was that?
দুটা আপনার কথা বলে দেখুন কৈ দিয়ক তেতিয়া
Yes, sir. Tribunal নাই দেখোন Lordship, perhaps Contention, this has become still now.
Let some other court say so. Counsel for the.
Chief, Mr. D. Upamanu is coming, Lordship. He's here.
You are here.
Lordship, in this matter, Lordship, we are going to file the affidavit today. It has
The
already,
order says we'll take it up without or with or without the pleadings.
Lordship, somehow it got missed, Lordship. We are filing it
That
today.
recent development in the division bench, does it affect them?
Lordship, otherwise, Lordship, his service was totally found to be fake. And Lordship, he is terminated accordingly, Lordship. There is no service.
How did he have a notice prior to that?
Lordship, since his entry was fake, Lordship, so we have
Come to a finding that his entry is fake.
because there were Lordship in the meantime, Lordship.
You have all the reasons to terminate a person. There is no doubt on it. Once you come to a finding, it is illegal, it is irregular, we don't interfere with it. What do we interfere with? The process.
Yes, Lordship.
Is it not? One fine morning, he goes to office. Sir, you are illegal, go home. Can it be?
Lordship, let it come up day after tomorrow, Lordship. We are going to file it today, Lordship.
Today?
Yes,
Day after
Lordship.
tomorrow.
Yes,
At the request of the Learned Counsel for the respondent, let the matter be taken up tomorrow. Only issue that you need to show us is
whether any
the
notice.
signature is forged. If it is a correct document given to a grade 4 employee by one of the officers, then all he can pray for is a show cause notice. Did he have that? His allegation is no. Then item number A,
10, miles.
10.
Huh?
Item 10.
Day after tomorrow, huh? Don't drag this matter. Give him a show cause notice, do what you want to do.
Obliged, Lordship.
We're looking on it, item 12. Yes, sir.
Yes, my lord. In this case, this is after long time, my lord. This is regarding appointment of secretary of the society. Present, I am not able to.
Secretary of a
cooperative society.
Appointed for how many years?
Yes, my lord.
How many years?
No, my lord. They continue up to 60 years.
6 years.
Once appointed.
Yes.
Lordship, before my learned senior start, Lordship, for respondent 3, though I have accepted notice in the first occasion, but this is made by name party. So you have to take steps, my lord. Chairman.
We are not lingering it. Have you filed your affidavit? The
Lordship,
department-
no extra copies have been served on last 2-3 occasions. They have taken time only.
My lord, extra copies, I'll verify.
No, I have not received
This
the extra
plea was
copies.
taken for the first
No,
time.
no,
my lord.
if you are not interested, we don't pursue it.
Lordship, 1 week's time.
Don't pursue it. It was last listed in 23. There is no interest on your part. Is there any interim order?
No,
No,
Lordship.
nothing as such. 1 week's time, my lord.
Have you been appointed?
No, on that, my lord, I have to.
Were you appointed?
My lord, I was selected. I was selected as secretary of the society pursuant to a, my lord, interview and advertisement. Then, my lord, the previous secretary who resigned, he was again, my lord, pushed into. He was, my lord, discharged due to corruption. So again pushed into. I have to, my lord, obtain instruction.
Department or a You are appearing for the department.
Lordship, for 1, 2, 3, 4, and 5. 6 and 7, he has to take steps. 7 is already filed affidavit. I have checked, but no copy has been served.
Who appoints it? Who appoints the secretary?
Society chairman.
Who is the chairman?
Chairman, board of director is there, my lord.
Oh,
Chairman.
Ask your respondent number 1 to 5.
1 to 5, I will file affidavit if required, Lordship. I will file affidavit.
From 2021, now you will file an affidavit.
Lordship, we are not appointing the secretary.
Ah.
The chairman of the
And you have not taken steps against the respondent number 6.
6.
6 has filed affidavit.
No, 7 is filed.
Seven has
Okay.
filed.
Who is
Private.
7 is
Chairman.
private respondent.
My lord, we have taken steps. That is why they
Just a minute.
filed the affidavit.
Just a minute.
6 to hold on. Hold on there. Okay. এতিয়া নাছিল।
One committee আছে।
এতিয়াতো আছে।
এতিয়া আছে না নাই নাজানো। সেইকাৰণে মই instruction পালোঁ। First page, he's 62 years in his affidavit, my lord, he said.
Who?
Page 1 of his affidavit.
Of whom respondent number?
Respondent number, my lord,
7.
7.
He can serve up to the age of
60, my lord. I have the guideline. I'll
62 he is serving.
We are not the appointing authority, my lord. The board.
There is a guideline, model rule, my lord, in which up to 60 years is the age to perform the duties. So that is why, my lord, tomorrow or day after tomorrow, I'll obtain instruction whether this man goes or the petitioner was appointed or not, my lord.
WPC 5198 of 2021. Print এটা ওলাই নেকি চাওকচোন ক্লোজ হ'ল নে নাই print 5198 of 2021. আৰু এটা look 4457 of 2021. List this matter again on. You want it day after tomorrow?
Definitely.
At the request of the learned counsel paying for the petitioner. Ms. Bora appearing for the
Cooperation department.
Corporate department shall have updated relevant instructions regarding to the functioning of the
Secretary of that society.
society in concern.
Man.
List along with the records of WPC number kiman kolu
5198.
of something 5198 aru kiman kolu 44. You can repeat. 4457 of 2021. Aru 5 of
2021.
2021.
My lord, fix the matter on lordship date
Day after tomorrow.
of this.
Yes, my lord.
Any resolution?
Yes, my lord. Well, here we're proposing, my lord, we'll hold an inquiry. We'll call the petitioner, we'll call the person from the district office, hold an inquiry in the department.
District office person may have been appointed maybe 2, 3, 5 years, 7 years, 10 years ago.
But regarding the payment of salary, because
Then he will
he's-
say that the documents were taken away by the CID and submitted somewhere, and therefore nothing
Maybe-
is available before me, and he'll keep
and
wringing his hands. Huh?
whatever documents we have regarding the screening committee, divisional committee report, that also will, because it's a more than 18,000 document. So give us 1 month time so that we can find out the document from each trunk and hold an inquiry to find a solution, my lord.
And Just now I have got a letter.
That is
One
fine.
letter communication issued by the block elementary education officer to inspector of schools. He stated that just now I have received the file. সন্মান সহকাৰে জনাও যে উপপৰিষৰ ইমান নম্বৰ মৰ্মে লখিমপুৰ জিলা খণ্ডৰ পৰা বিহপুৰীয়া প্ৰাথমিক শিক্ষা খণ্ডলৈ শ্ৰীমতী ৰঞ্জিতা বৰগোহাঁই বদলি হৈ আহি 2006 চনৰ মাৰ্চৰ মাহৰ বেতন ভোগ কৰে বৰ্তমান বেতন পুৰৰ পৰা বঞ্চিত হৈ আছে but transfer after transfer 1 month she getting we are receiving in Lakhimpur and thereafter transfer to Bipuria and we got 1 month and thereafter my salary was stopped.
What we can do is this.
Right.
Some documents are yet with you, not in the writ petition, my lord. There are some documents with them. Inside that trunk, they don't know. Appear before them.
Yes, my lord.
Give your documents. Give them some time to trace out the numbers of the documents because there have been cases where we found appointment orders were issued in they call it scholarship files. The file number is of a scholarship file, but it is an appointment letter being issued by certain person. We have found those situations.
Right.
Therefore, with all your numbers, all your letters that you have, once we place it to them as early as possible, they can have a particular inquiry made with regard to your this thing. This will help in other cases also because they will know which record is lying where. At least that much they will come to know this is how we label the records now. It cannot be kept in trunks as sent by the. We'll have it listed in the next month, early next month. By that time, complete your inquiry regarding this person.
Right.
That is only to a certain extent. Otherwise, unless it is a fake document, the records showing that she has served, salary would be the answer. Is it not?
Yes, please. If she is illegal is illegal. If she is illegal is cannot run, my lord. So that is if he is genuine, my lord.
আধা অৰ্ডাৰ এগৰাকী লৈছিলে সেইটো নালাগে লিখিবলৈ সেইটো মানে সেইটো উলিয়াই পেলাই টাইপ কৰি ইয়াত থৈ দিব মোৰ কাৰণে মোৰ ৰিমেম্বাৰিঙৰ কাৰণে পাৰ্ট অফ এন অৰ্ডাৰ মেক ইট মাই নোট এতিয়া আপুনি লিখি লওক Heard Mr. N. Bora, learned counsel appearing for the petitioner. Also heard Mr. N. J. Khatonia, learned standing counsel education department, assisted by Miss A. Bhuya, Joint Secretary to the Government of some Department of School Education, and Miss Swenson, appearing on behalf of the Department of Director of Elementary Education. Some. Stop. The matter has been heard for some time and it appears that the writ petition although has given all relevant documents regarding to the claim for arrears for salary, the writ petitioner is in possession of certain other documents also which may require a verification by the department. It is not only the verification that would be necessary, since the matter is, since the appointment of the petitioner took place on 2021 and her transfer was effected in 2006, the history of service of the petitioner would also perhaps require to be taken into account. In such a situation, at the consent of both the parties, both the learned counsel for the parties, consent of both the learned counsel for the parties in presence of the departmental officials as aforesaid, this the writ petitioner is directed to appear before the office of the whom? Your office.
Department of School.
Before Srimati So-and-so, Joint Secretary to the Government of Assam, Department of School Education. Give us a date, madam, to your convenience, when it would be possible.
Maybe on 10th February.
10th of February, sir,
Tuesday.
can arrangements be made? 10th of February, it's a Tuesday.
Mine.
10th of February 2026. During the office hours with a prior intimation. The aforesaid officer. Full stop, the petitioner shall carry and or produce all such documents which she may have in her possession to show her appointment, transfer, joining, receipt of salary or continuous service in the school concerned. Full stop, the petitioners will be allowed to be assisted by the council appointed by her to assist only for production and detailing of the records being produced by her. No arguments in there. No one will argue in there. They will give the document and they will assist her in production of the documents.
Pass an appropriate order.
Huh? No,
Pass an
they will
order.
not pass an appropriate
order.
order.
Place before the.
The department would thereafter conduct the verification required of the documents and place a report before this court as to the continuity, report before this court regarding the veracity of the documents so produced. Full stop. This court observes that there is no denial in the affidavit filed by the erstwhile on behalf of the director regarding the appointment, transfer, or continued service, at least till the date of filing of the affidavit in opposition. Full stop. The only ground taken in the aforesaid affidavit was that the name of the petitioner appeared at serial number 07522 in the state list of irregular illegal teachers appointed during the period from 1991 to 2001, and that the report had been sent to the government after preliminary screening of applications throughout the state. Full stop. The affidavit thereafter records the decision of the government for re-verification of the particulars of the applicants by the screening committees in respect of the aforesaid 4 districts. List this matter again on. When can you have the report ready thereafter? When can you have the report ready thereafter?
Yeah, we'll have to check those, what's available in the trans. This time.
Have some more. You are appearing on the 10th.
10.
We'll have it on March 2nd
March
week.
Second week.
March 12, 19.
March
19.
1930.
6th one of Duke. 5th by 6th. 5th or 6th?
6. Can be taken up on 5th.
5th of March 2026. The writ petition is of 2017 and it is expected that the officers concerned would act with due promptness. Full stop. The further requirement of the personal appearance of the officers concerned would be considered on receipt of the report on the 5th of March 2026. For the present, the officers are the personal appearance on 5th of March 2026 is dispensed with. We'll consider it again. If we do not find an appropriate report, an understandable report, we may ask you to explain it to us again. If it is comprehensive and we can understand the report, we'll continue it.
Taken up
Obliged.
part.
Huh?
Part has man. Already 2017 matter.
The matter has been considered at length.
Much please.
Obliged.
Please, your lordship, matter relates to compassionate appointment, my lord.
Oh,
Lordship, I have filed for 13. 13. My application was considered by the district level committee, my lord. That lordship will find in page 19, serial number 11, my name was appeared. Page rebel portion is page 20.
where was it rejected?
Lordship, rejection is lordship, page 22, annexure 7, lordship. The relevant portion is page 23.
For want of vacancies?
Want of vacancy.
Yes, wrongly done.
Lordship, because district level committee has considered against 2 number of vacancies, lordship. There were 2 number of vacancies, lordship, by the district level. There are 2 vacant posts available, lordship, and that was forwarded before the state level
This
committee.
court
lordship.
has recently passed an order.
Yes, lordship.
Compassionate appointment cannot be granted now, even if there was a mistake on the part of the respondent authorities.
Lordship.
However, they'll be liable to pay you a compensation.
Lordship.
Get the judgment?
And the
Is that
judgment of the division bench, lordship.
It says what?
Lordship, for want of vacancy, they cannot reject, lordship.
How recent is it?
Lordship.
How recent is it?
Lordship.
How recent is it?
Lordship, it was of lordship 2018.
Huh?
2018 judgment.
We are talking of
And there are 7
January
judgment of single bench,
2026.
lordship.
We are talking of January 2026. All this has been considered there, every judgment. Recent judgment, kindly find out 1 lakh compensation is the base deal. 2014, once a
Lordship,
person,
at that point of time, lordship, office memorandum, there was an office memorandum, lordship, 2015, that was also existing, lordship. They may consider in any vacant post of any department, lordship. That was also.
as of today, the compassion, the requirement is gone.
Yes.
It is gone. Now, if it is gone, it was due to their fault. Apex Court says, whosoever fault, close the chapter. So we'll have to close the chapter. It was their fault. The best you have is a compensation. That has also been quantified by this court recently. Find out the quantity. Compassionate appointment perhaps will be out of question. When do you want it? Friday? Do you have that, sir, with you, that judgment, recent judgment?
Also, I have to go to it. To check on this code, also, I have to check, lordship.
Pre-notifications in live law is coming up. You are not.
Otherwise, lordship.
Yes, Mr. Talukdar, on 6th.
Lordship.
His matter, once it was been rejected by the SLC.
Lordship, 2nd week of February, lordship.
It was well communicated to
12th?
Lordship.
12th of February. At the request of Mr. R.K. Talukdar and Council appearing for the petitioner, list this matter again on the 12th of February 2026, allowing both councils to acquaint themselves with the recent pronouncement in respect of similar matter.
Yes.
Yes.
The Lordship, on the last occasion, the standing counsel of PHA was supposed to file an affidavit regarding this matter.
We will file it, madam. If the case was not listed for some time, we will file it in
Cost.
one final.
One initial cost.
Madam, that
2022, 2021. Heard, Mr. Heard, you are?
Yes, Saranya, on behalf of M. Saranya.
M. Sarania. And counsel for the petitioner. Mr. Abba Thakur, learned standing counsel appearing for the
PHE, madam.
PHE has submitted that they would be filing an affidavit in opposition. Full stop, it is noticed that the matter is of 2021 and has been pending before this court only due to the absence of the affidavit in opposition by the respondent authorities. Full stop. In fact, on the initial date, an observation had been made that the interim order should be considered on the next returnable date. Full stop. Yes, you want to say something? No.
Just appearing for respondent number 5, Lord.
Ah. As a last opportunity, the respondents are allowed time till Tuesday date,
My lord, 16 February. my lord.
16th of February 2026 to file their affidavit. If the affidavit is not filed within 16th of February 2026, then and such affidavit is filed on a later date, the same shall be accepted only on deposition of a cost of rupees 5,000. Full stop. In case no affidavit is filed before the next returnable date, the respondents would be heard only when they pay a cost of rupees 20,000. Full stop. The petitioners would be at liberty to file their rejoinder, if any, to the affidavit in opposition, if any, filed by the respondents before the next date of listing. List again on the Tuesday date. When do you want it? To file your rejoinder and then have it listed.
23, Lordship, 23 of February.
23rd of February,
Okay.
2026. You file it within 16th, no cost. File it after 16th, 5,000 cost. Don't file it till the 23rd.
23rd, yes, Lord.
20,000 cost if you want to be
We'll
heard.
file it, my lord. Lovely.
None appears for the petitioner on call. Matter relates to compassionate appointment, a full stop. The father of the petitioner expired on
27, 2016.
20th of July 2016.
Application submitted on 23, 3, 2017.
Petitioner had earlier approached this court in the year 2019, and the subsequent rejection of the petitioner came on 29/2020. The writ petition has been filed on 15th of December 2021. Place this matter again on Ukurbar, Friday, 6th of February 2026. Full stop. Affording one opportunity of appearance to the petitioner. Yes.
Please, Your Lordship. I'm on behalf of Mr. H. Omayo.
Mm.
He is late in court number 5. So
Mm.
can it be after some time, Your Lord?
After some time, madam?
That's all, Lordship.
22.
Mm.
A very short point is involved here. My lord, he now has retired from his service.
Mm.
My lord, he came before this honorable court because his pension, he was working in State Bank of India. Now the loan was provided to him, but the purpose for which the loan was provided, he has not utilized it
Mm.
for some other purpose. Then suspension, thereafter, my lord, reply was given. He wanted to go for VRS, that was not allowed.
Mm.
Ultimately, my lord, there was an order where this, your lordship will kindly see. He was at page 53. This is a dismissal order.
Mm.
At page 53. He was dismissed from the service.
Mm.
And this was put to challenge before the learned single judge at page 62.
Mm.
Now, your lordship will see at the operative that was not interfered by the learned single judge.
Mm.
And the
Went up in
writ
appeal.
petition was dismissed.
Mm.
My lord will kindly see at 71. In view of the reasons stated above, this court finds no merit writ petition. Writ petition is accordingly dismissed.
Mm.
This was put to challenge before the division bench. Now the issue was whether I have put in how many years of service. Now there is a finding, categorical finding of the division bench saying that I have put 23 years of service, which was not disputed by them. And records were even asked to produce, they could not produce the record. So now, if your lordship will kindly see the order of division bench at page 72. 72, kindly see at page 72. 76, my lord, paragraph 11, my lord. Kindly see para 11 at page 76. May I just read, my lord? We have also observed the appellant has been serving for the last 23 years in the bank, apparently without any adverse remark or report. Though we had given several opportunities to the bank authority to produce the service record of the appellant to enable us to see whether it contains any adverse reports or indicates any other unbecoming behavior of the appellant, the bank has not been able to produce his service record. And as such, in view of the categorical assertion made by the appellant that there is no such adverse remark or report in his past service, we take it to be correct in absence of any record contrary to the same. Number 12, if the appellant has served for 12 years without any adverse remarks or report against him, we are of the view that dismissal is the highest form of penalty, which would entail denial of any service benefit, including pension, perhaps may amount to be very harsh. We have also taken into account that by aforesaid misconduct of the appellant, no pecuniary loss was caused to the bank. We also have taken into account that it was the internal administrative act of the appellant, which did not come to the public limelight, which could have caused embarrassment to the bank. We have also seen the appellant in the first instance and apologized for his misconduct and also offered the reason for doing so. Therefore, under the circumstances, we are of the view denial of the benefit of the entire past service rendered for 23 years perhaps may amount be too harsh considering the mitigating circumstances as referred to above. Accordingly, we are of view bank authorities may take a more lenient view as far as quantum of punishment is concerned by resorting to any other punishment which is available under rules as quoted above, so that at the end of the day, when
What was the period of your unauthorized absence, sir?
Yes. Now, what they said?
No, according to them, what is the period of unauthorized absence?
They said from 2000, my lord, the unauthorized.
Page 83.
Yes. But your lordship is right. My lord, what my submission before what they have done it, after the judgment was passed, it went again before the authority concerned. The authority concerned, now what they have done it, at page 80, kindly see it, at page 80, my lord, see para 2, my lord. Kindly see para 80 page, para 2. After applying, your lordship got it? 80. After applying my mind independently and dispassionately with regard to the case, taking into consideration the observation of the Honorable Guwahati High Court and all other aggravating and extenuating circumstances and gravity of the misconduct, I have decided reconsider the penalty and to inflict the following penalty upon you. Now, this is be discharged from service with superannuation benefit. That is pension and or provident fund gratuity. It would be due otherwise under the rules or regulation prevailing at so and so, so and so. Now, what they have done, if your lordship now looks at page 85, lordship got it, 85? With reference to your letter, I immediately wrote to the bank saying that after this, you have superannuated me, giving me pension and gratuity, but you denied my pension because they are saying for getting a pension, you have to work for 20 years. Now, my case, what I am projecting before this honorable court, that now one, you have considered my case in pursuance of High Court's order. Now, there is a finality of the judgment of this court of division bench where it said that you have rendered 23 years of service. That has become final. My lord, they have not put any challenge before any court. Now, the punishment was harsh. So, High Court said that you look into it. Now, what they have done in my lord, they have said that, okay, what we are doing is, we are superannuating you with pension and gratuity, but no pension because 14 years of service you have put in. Now,
When did you join the bank?
Yes, I joined the bank, my lord, 27th of February 1987.
27 February 1987. And how does it come to 14 years only?
Now what they have done is 14 years, 11 months bank.
From where they have got?
Yes. Because there was some unauthorized leave
From when
on
to
this
when?
unauthorized.
From when to when, sir? That is what
Yes,
I'm
I'll
asking.
just give you a date, my lord. That's it. Date. And when?
November.
Oh, where week is that week?
For the bank, can you tell us?
My lord, yes.
I
Yes, ma'am.
just put it.
My lords may directly come
No,
to.
just tell us that what we are trying to know.
My lord.
The period of unauthorized absence, what is that period? From
I'll
what day to
pay
what day?
23.
Huh?
If your lordship looks into page 23,
23, yes, sir.
we applied for VRS. No,
Page 87, there is some letter we were trying to find out. Page
80?
87, there was something you applied on so-and-so date, then it was cancelled on so-and-so
Yes,
date.
yes. I applied for VRS, my lord.
When?
Into page 23, my lord.
Ah,
2004.
ah,
But that was not considered.
then
That was not, VRS was not considered. He said you have to continue.
you joined in 1987.
Yes. 87.
So how many years do you need?
My lord, I need
According
20
to
years. 20
Huh?
years.
20 years.
20 years.
So he needed to continue up to 27,
Yes, my lord.
2007.
He required to have pensionable for, in order to get that pensionable service, he was supposed to have that 20 years completed.
When would it be completed?
It would complete, my lord. Had he completed it, my lord.
When would it be completed?
My lord, with that we need to calculate, but I
20
have,
years from 1987, how big a sum are you calculating, sir?
no, my lord, what has happened?
Tell us when would he have completed it if you don't bring in the complexities in usual course of life,
My lord,
without all these disciplinary proceedings, when would he have completed it? Answer what we asked.
2007, my lord.
2007.
My lord.
When was he first inflicted the punishment of termination of service?
No, my lord,
7/4/2010.
7/4/2010.
17/4.
7/4?
17/4/2010.
2010. Okay.
10.
Then when was the, this is order, the first.
Dismissal order,
First order.
19/8.
Then when was
2010.
your penalty order issued, the next one, the retirement order retiring him? This was on 2022.
my lord.
8/8/2022.
My lord, that in view of the division bench order, penalty imposed on modified to discharge of service with
No,
superannuation. benefit.
modification, this modified 2010 order.
Yes.
This modified the 2010
Correct.
order.
Correct.
Because of the High
Now
Court.
kindly tell us what is the period of unauthorized absence?
My lord,
From
total
which
is
date to which date?
my lord, there are different heads, my lord.
We're looking at 2004, he applied for VRS.
My lord,
Is it?
my lord.
Page 83. You applied for resignation in
2003.
2002.
Yes.
Withdrawn in 2003.
Yes.
And we first understand the facts. We'll
My
come
lord.
back to every submission.
My lord.
Give us the facts.
I-
don't confuse
My
us
lord,
when we are not-
absolutely.
Let's give the
So-
facts. On 27/2/1987, he
Okay.
joined the service.
27/2/1987.
7/2/1987. He joined
Ah,
in Fancy Bazaar Bank computer operator.
joined.
Then
Then-
1994,
Ah.
petitioner obtained a housing loan from SBI.
Housing loan.
From
Yes, sir.
SBI. Now,
Then,
2003, the petitioner applied for VRS for the first time.
no.
He
Applied for
VRS
Applied for VRS on 2/9/2002.
2000,
Page 83.
page 83. 83, madam. You applied for resignation on 22/9/2002, which was withdrawn.
Now
Why
this was
your letter dated 4/1/2003, my.
just a minute, sir. Withdrawn. So once it was allowed to be withdrawn,
Again,
the
I applied.
period between the application for resignation and the withdrawal period becomes continuity of service.
But he was, my lord, correct.
So therefore you could allow him to rejoin because he was in service. He attended for the day or not into the bank is another matter.
My lord.
But he remained in service.
Correct.
Okay. Then you again applied for resignation on 21/4.
Correct.
Is it not?
Yes.
21/4/2003 again resigned. Which was not considered by recommending authority. And you had told him on 6/6.
Yes.
6/6/03. This is rejected, right?
Hmm.
So he continued in service.
My lord.
Your application on which was acknowledged by address to you. Your advice will continue to be report to duty as until December. Your advice will remain absent from your duties thereafter without any. So now from 11/10/2004 to when? When was he first terminated? 2010.
I was dismissed first on 17/4/2010. At page 60.
To 2/1/2008.
2/1/2008, I was
Now we have
rejoined.
unauthorized absence. 10/10/2004 to 2/1/2008, sir. The last few lines, if we have, of if page 83.
My lord.
83, I'm
If
reading.
the council can read.
That's my application. Last 3 lines.
No, at the top, you submitted another application.
You
for
submitted your
resignation
another application for resignation on 10/10/2004,
Huh?
which was acknowledged
on 11/10.
on 11/10/2004 as addressed to you.
But
in
you
the-
remained absent.
Yes, in this letter, you advise they will continue to be in the bank service on report of so and so. My only point, here my making it very simple. My lord, what they are saying, you are not entitled to be in 23 years. With the division manager says you have 23 years of service. That is final. Now you cannot go back and say that I 14 years of service.
Sir, can we meet at 2?
Yes.
We'll come back at 2,
Yes.
sir.
My lord.
17 to 20.
This was a matter regarding
This is non-payment of salaries and retirement benefit of employees of a cooperative bank.
somewhere in the middle, you wanted to.
As per your
A
lordship.
statement was made that it was not to be done by you, since you were being appointed as a standing counsel. And there was a retract.
Yes.
When do you want it?
For your convenience, my friend is also having some difficulties. To some other day, some
And then the my lord may fix in matter on the month of February, my lord, 11th of February.
11. Yes, yes.
11th.
Deeply obliged, lordship.
11th or the civil criminal order. Today is a falling day.
Today is a falling.
We are hitting everything.
Let us not fall, millet.
Hmm. 11 arrives. 11th.
11. Deeply obliged.
Yes, Mr. Dasyoma.
Facts, my all facts, your lordship, want to be clear.
Ah.
So my lord, just facts, your lordship, and note down. Just recollect, 2002 VRS applied. Then it was rejected. 2003 again VRS resignation applied, that was rejected. Now in 2004 I was placed under suspension.
What was the date?
2004 I was placed under suspension.
Suspension
Find it.
since?
Suspension order. Case 27 was the suspension order. And 26 is a type copy. There ought to be, kindly see, my lord, that's important. This will be proceeding against you. Your
And
lordship.
when was this revoked?
It is not revoked. 2004 it was suspended, and in 2009, 2009, my lord, disciplinary proceeding, so cause was issued.
Okay.
So cause was issued on 6/10/2009.
6/10/2009.
2009. And my lord, the so cause which was issued was alleged diversion of funds in a not unauthorized leave. That's your lordship will please look into it.
No, one simple thing.
Yes.
You have been alleged to be absent from 11/10/2004.
Yes.
2/21/2008.
Yes.
Is that what we understand? Absence is 10/10/2004.
No,
You
my lord,
go
it is-
again go by your letter of 83.
My lord, perhaps
Page
29
83.
My lord. Yes.
2002, my lord.
There, what is their stand, my lord? Your lordship is asking correct. I know why your lordship is asking. Now, unauthorized leave. That they now their stand, they are coming before this court and division bench, which was nullified by division bench. Lot of opportunity was given. Show the service record to justify that this is unauthorized leave.
No, we will simply go by the fact that he was placed under suspension on 11/10/2004.
Yes.
Is it? And the show cause notice came on 6/10/2009.
And my dismissal.
And counsel for the bank would kindly clarify if there is a reinstatement in between.
No, my lord.
No. So he continued in suspension.
Yes, right.
Then he was dismissed on certain date.
My lord.
19.
Prior to that, no reinstatement.
No, my lord.
Done. So a person who continued under suspension,
My lord.
how do you call it an unauthorized absence?
My lord, that is in 2008, not in 2004, my lord.
Sorry?
2008, my lord.
When was he suspended?
Focus was caused in 2008, my lord. He was.
When was he suspended?
2004. This is on record. Your lordship will see the record. And his letter at page 27. Yes, 27, which is type copy, is at page 26. His letter, his own letter.
My lord, what my learned friend is showing is page 26, my lord. May I read, my lord?
I have read it.
My lord.
When were you suspended? Your suspension order?
My lord.
Just show me the suspension order.
My lord, may I show page 55, my lord?
Yes.
Page 55, my lord.
Any page to your convenience.
Page 55, my lord. Page 55, my lord.
5, yes.
With reference to the above, show cause notice dated, notice had been issued to you on 6/10/2009. White memo number so-and-so, dated so-and-so. You had submitted written statement of defense, white your letter dated 14/10/2009. The disciplinary authority, after proper examination of the case and the reply submitted by you, found that there are sufficient grounds to proceed against you departmentally. According to the
This is
department,
an order of
award, my lord.
2010.
My lord.
Tiny question.
My lord.
When was he placed under suspension? I cannot make it more.
My lord, I gather from what my lordship
or I
wants to
can
know.
have I can give you a room with many walls and you
My
can
lord.
continue beating all the walls.
My lord,
Nowadays, we have lesser number of bushes to beat
My lord.
around.
my lord, in that case, my lord, can it be taken day after tomorrow, my lord? We'll find out from the bank and then come up, my lord.
Before the writ appellate bench, you could not.
My lord, because my lord, what has happened,
What is your ground for saying it is an unauthorized leave in the teeth of the argument that he was placed under suspension?
No, my lord.
He was never under suspension.
No, he was under suspension, obviously, my lord.
Tell us the date. That period in which he was under suspension will not be unauthorized leave.
My lord.
If that makes him complete his 20 years.
My lord. Then is entitled. Like we absolutely agree to my lordship's. That is absolutely the case, my lord. We only say that unauthorized absence will not come under that proviso of 22. That is the
Even then, if you want to go for that, then you are treating it as dias non.
My lord.
Is it not? It will be treated as dias non or it will be regularized.
My
It has to be first regularized.
My lord.
Before you can take action against it. To regularize it, it has to be termed as dias non, not in only in the name you are in service, not for any other purpose.
My lord.
Before making it dias non, service law says before you make it a punitive action, you must give him a notice.
My lord.
Notice not being there, you have taken a final decision.
My lord.
Now a notice to him will be a eyewash,
My lord.
just for the sake of it. That notice will not come now. Since the unauthorized leave or dias non, he never had an opportunity. It will be deemed to be in service for all reasons except for the purposes of salary and benefit or arrears. He is not asking for that. Calculate, take it to be and finish it as a pension. An order of 2.5 pages.
My lord. I absolutely get, my lord.
Suspension order
My
and suspension revocation.
My lord.
After heard Mr. D.K. Das, learned senior counsel appearing for the appearing with the assistance of Mr. So-and-so, learned counsel appearing for the petitioner. Also heard Mr.
A.K.
So-and-so,
Sahiwal.
learned counsel appearing for the
Bank, my lord. A.K. Sahiwal.
bank. The matter has been heard and it is only at the request of the learned counsel for the bank to produce the document by which the petitioner was placed under suspension and the order by which the suspension was revoked. That this matter is directed to be released on day after tomorrow. You are here, sir?
My lord.
If it is not on Friday.
On Friday. Huh?
Friday morning.
Friday.
Morning. 11th, my lord, then?
11, no.
Huh?
Dos.
Nine.
No, no.
9,
Dos, 10.
10,
Nine?
10th, my lord.
10th,
Ten,
10th, on the 10th of February 2026.
My lord, only one small request that I would like to make. Your lordship will be aware that there was absolute fire at the GS Road in SBI. I don't know how far, since your lordship has directed to produce the documents, I don't know. Because we were behind State Bank to find out. We'll try
The
absolutely.
benefit of everything.
Absolutely. I bow down, my lords. Only thing is that the entire office got.
Because it is your decision to give him pensionary benefit.
Absolutely.
What we need to see is whether
He's eligible or
a
not.
certain period.
That
Otherwise, he is eligible.
your lordship has absolutely understood the matter. That is the clerks, my lord.
Any further on this? Because Mr. Das, just for what I was thinking, the division bench in very particular words or the single bench, even for that matter, none of the earlier judgments. The question, it was never before the court whether you had a continuous service or not, whether there was unauthorized leave or not, absence or not. The only issue was whether the disciplinary proceedings were appropriately handled by giving out a reasonable punishment. So that period, that 23 years, continuity will be there. 23 years is correct.
Yes.
But for the time that you remain unauthorizedly absent, law provides for that also. It can be taken away. If not taken away in the proper form, then we will interfere. And now, after such a long period of time, to give it a quietus, it will be simply, if not done proper, now no opportunity to do it. It has reached a finality. The decision to grant pension is final. In that decision, you did not spell out to him that, look, sir, although we are trying to give you everything, you run short of this period. Even then, you did not tell him.
No, my lord, we did not have any occasion
So
to say
therefore,
that.
the discipline authority at that point of time did not take into consideration that fact.
No, my lord, see, whatever falls, my lord, under that preview, under that section 22, that rule, he will get
It's
it.
not that. Do you think a disciplinary authority will have the power to inflict any and all punishments without looking into every aspect of the matter?
My lord, that is not before lordships to be challenged, my lord.
It is.
My lord,
Whether
the
you can-
division bench order is not.
whether you can take away his 7 to 8 years after the disciplinary authority has made up his mind to grant pension.
My lord, I'll satisfy my lord.
Bring us that.
I'll satisfy my lord.
If the period covers, he has a case.
My lord, we'll satisfy my lord.
Because only what I'm worried that whether they can produce the record. I think they will. That's my only apprehension.
That would be
If we
God's
can-
blessing.
Right, because
God's way of-
all the time, the number of opportunity was given by division bench. You produce the record, they could not.
And
That is why-
unfortunately, at that time, there was no fire.
Yes, that's right.
No.
Correct, my lord.
My lord,
And
here-
23 years of service, that is confirmed by division bench with great respect. If you are aggrieved, you could have gone before higher
Then we have
court.
to fall back only on
Yes,
that.
like you
Now,
could
if the
have-
records are not there, we'll have to.
Now,
fall back.
now what they are turning back and they are not adhering to a judgment of the division bench. They are saying, no, 14 years. From where you found? They have given a chart in their affidavit. That chart only indicate this is the period unauthorized, this is unauthorized. Where is the record to show before the division bench also? Now they are coming with a different case. No, you are not entitled.
My lord, can
They are denying my pension. Your lordship rightly said, the period I am not asking. Give me my pension at least. Pension you should give it. What they have done, Provident Fund gratitude they have given 14 years. But that also has been denied. I have written. Please, if it is 23 years of service, division bench confirms, so you have to pay me. Pension has to be not to be denied. Now they are coming with a different story.
my lord, these salary slips, if my learned pen can produce, if he has.
Why at this stage, where is the question?
Because salary slips, that will come up, my lord. If he is unauthorized absent, he will not have the salary slip, my lord.
She may not have a salary slip because she kept it at the with a friend who had left her
Malas-
bag in the State Bank that day when the State Bank caught fire. We don't know.
Hi, my lord. Account statement or anything, my lord.
It is your stand that she has not got salary. It is your stand that she was unauthorizedly absent. That much you have to do.
My lord. I'll
We
try
will
my
not
best.
impose it upon her. Just like
If
we
they are
do-
entitled, my lords, we will absolutely pay.
we will see.
My lord.
But
See,
only
get
one request, humble request. My lord, I'm so sorry, my lord.
No difficulty.
It can be on 11th.
It is on
11th.
It is on 11.
11th.
Or did you say 10th?
11th. Why?
10th question. No, 11th.
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 Be
Yes.
clear. Yes.
Grateful.
কেইটামান ঢোল কেইটামান আছে আন্দাজ ল'ব পাৰোঁ Yes.
May I please?
Hmm.
Your Lordship, can I draw your attention to the order of this court on 15/12/2025?
Yes.
If I can bring you to para 3 of the order. I'm
The
just,
maintainability part.
yes, no, not the maintainability part, because this paragraph particularly summarizes very succinctly what the petition is about. I will just take you to para 3 entirely. Para 3, 3.1. Just 3 and 3.1 is sufficient for the time being, ma'am, Your Lordship. Now, question that was raised to us was whether this writ petition is maintainable against a private respondent. Now, based on this order and based on the arguments so far, 3 broad questions of law have been put before us. One is whether a private university is amenable to writ jurisdiction and when. 2, if the university at all performs any public function, then where does the petitioner locate herself within it? As in, whether this petition is based on, say, the determinability of a contract or regarding the specific performance of a certain clause of the contract. And 3, at what point, if at all, the university becomes a public authority, at what point does this journey happen? And when it does, where again does the petitioner locate herself within it, not just as a teaching staff, not just as an associate professor, but also an UGC approved PhD supervisor.
Okay.
Right. So now, your lordship will see throughout the order is seen and throughout the petition, there is absolutely no mention of any contractual clauses because there is no contractual point at this stage. What we are relying on is the UGC Act 1956, which is a statutory law, the regulations that come out of it, the UGC regulations, and the PhD grievance and disciplinary regulations. Now, regarding the first question, is the university amenable to writ jurisdiction? Firstly, there's a second compilation of judgments that we have submitted, my lord. If you have it. Compilation 2. At page 13 of compilation 2, my lord. You have a judgment of this honorable court in which, in an RTI application, a private university has been found to be covered as a public authority.
We are not having compilation 2.
Compilation has not been served on me either. Your Lordship.
This is brief written arguments against the respondent affidavit dated 16 January on maintainability of writ jurisdiction.
Right.
Then we have annexure P1 at page 37 to 142.
Okay. Do you have written submissions? You have the written.
I have the written submission, yes.
I have quoted the relevant para in the written submissions. There's a table. I'll take you through that one in the meantime. The table is on page number 24 of the written submissions. Okay, you have it? Right. So this is the second on the table, the second case, Indira Gandhi Technological and Medical Sciences University versus State Information Commission, in which it has been found as this. As per the provisions under 2H of Chapter 1 of RTI Act 2005, the expression public authority in the latter part of Section 2H, that is body owned, controlled, substantially financed, non-government organization, substantially financed directly, indirectly by funds provided appropriate government by the appropriate government.
This university that this Assam Royal Global University is also by an act?
It is a private university, my
It
lord.
is by an act?
Yes.
By an act of the state?
Yes. Assam Private Universities Act. And it falls under the RTI jurisdiction of being a private authority. Now, what is a private authority under the meaning of 226 of the Constitution of India? This is quite a settled law, as we had seen in the case of Andi Mukti, that described the constitutionality and the meaning of the word authority, as in Article 12 and 226. It reads, the term authority used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under 32. Article 226 confers power on the High Court to issue writs for enforcement of fundamental rights as well as non-fundamental rights. The words any person or authority used in the Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any person or body performing public duty. The form of the body concerned is not very much relevant. It is relevant in the nature of the duty imposed on the body. The duty must be judged in the light of the positive obligation owned by the person or authority to the effect of the party. No matter by what means the duty is imposed, if a positive obligation exists, a mandamus cannot be denied. Now I want to hit the point straight to the question of whether or not a private university falls under the function of public function, whether it is performing any public function in the first place.
Moment it is teaching, it is doing, that is a public duty. Relationship between you and the university.
Yes.
Whatever has been done to you, whether it was done in the discharge of public duty or whether it was done within the administration of a private institution is what you have to hit upon.
Right. If I let me just explain the facts then, my lord. What happened to me was the termination was a byproduct of what was happening. I raised some fundamental issues regarding ghostwriting, regarding PhD rules and governance mechanisms being followed as per the PhD regulations. I have the university PhD regulation, which in the end says that everything is superseded by the UGC regulations on PhD. So that is clear. Now, what happened? The termination letter says that I have been accused of misconduct, not taking professional advice, etc., etc. Though there was never any show cause, any notice, any disciplinary hearing, or anything whatsoever. Now, what happens at this juncture is I have about 5 or 6 students who are doing their PhD under me. 2 of them are in their final month of submitting the PhD. Now, my intellectual property right that flows from these PhD regulations are being violated because now they have been allotted separate PhD guides, supervisors, and whatever I have worked with these students in all these years are taken away without an NOC from me, which flows from the PhD regulations. There is no private relation in this exchange at this point because everything that we are referring to are the UGC regulations on PhD. And therefore, irrespective whether there was a contract, well, if they had discharged me of duty, say on business reasons or for any other reason, whatever the reason it would be, I had written them a letter that I'm willing to serve you without payment because the last month my PhD students are graduating and my intellectual property will go. But that also was not done, and my PhD students are now having if
you think your intellectual rights are being violated, you get an order from somewhere that whatever you had done within till the time they had taken you away, they will use none of the materials for their PhD. Get an order.
But we have written to them, my lord. But that to the university.
The students don't use anything. It's my intellectual property. I'm no longer your guide.
But yes, the students have been involved anyway that they are no longer their guides. However, till now, the students in any case have been allotted new guides. And that also impacts, of course, their personal academic situation. But in general, the work that I have done all this while, that has been taken away. And the PhD regulations fall flat. And I have also at 150 of the written submissions given a list of, I think, 3 private colleges who have lost their PhD license because they were not following the PhD regulations.
To their risk, whatever they are doing is to their risk and this thing. Need not worry about how they will survive. You have to show us that a termination of service.
Yes, my lord. You want the termination letter?
I read a book.
Have you, what was that case where we set up that educational tribunal? The full court decision where we set up this educational tribunal, 2013 matter. Mondal.
The Guwahati High Court, sir?
Huh?
I apologize, I'm not aware.
No. Abdul Ghaffar Mondal, that discussed TMAPI and all the other cases.
Correct.
What kind of a discharge of duties a public will come under which jurisdiction?
40 lordships, mostly. We are mostly concerned with Article 12 in this particular,
in 226.
Definitely, 226 and the powers of this honorable court. And whether the respondent university is actually
private institute or whether it would be considered an other authority under Article 12 of the Constitution of India. That is the simple debate.
That is what I'm saying.
Judgments, Your Lordships, it is absolutely well settled by the Honorable Apex Court. We need not go very further.
Service matters
Service matter.
between a private institution and the
It has to go, she has to go to the civil court to fight her rights
We
because
cannot,
of
we
the very
cannot go to
simple fact.
civil court to
Lordships,
enforce UGC Act.
Lordships, if I may just be allowed to just,
we
I will not, I will not interrupt
we're
you.
not.
I did not interrupt you. Let me just.
I asked for her. She didn't stand up. I asked. Yes.
Lordships, the University Grants Commission is a regulatory body. And accordance to that regulation act, the UGC Act, all universities which are framed under the State Universities Acts, your Lordships are aware that there are several private universities in India. Each university is made by a State University Act of that particular state. The UGC is only a regulatory body to the effect to show that the university is complying with the educational standards which are to be maintained in each university. Further, the UGC also grants permissions insofar as degrees are concerned, as to how a degree is to be given. And the degree is recognized as per the UGC. If the UGC does not give me, a recognition, then I cannot grant a degree to any student. Now, in this particular matter, my learned friend has been talking about UGC. She has not deemed it fit to make UGC a party respondent in the instant writ petition. Number one. Number two, she is in her written submission. She has also talked about section 2.5 of the UGC. She has not even bothered to annex that as a part of either her submissions or the writ petition or whatever pleadings have been exchanged till date. She is relying on that heavily in the reply. If I may just show your Lordships 2.5, Nikalo. What exactly does 2.5? She's saying that we are bound by 2F. I'm sorry, not 2.5, 2F, your Lordships. If I may, what can you copy, Dave? This is the code. If I may just take your Lordships for a moment to 2F, what exactly is it? Extra copy hai? You should have it since you are the one who is talking about it.
I didn't say I don't, but I don't ever refuse a pre-code.
Thank you. Lordships may kindly see it's a definition, and it defines what a university is. University means a university established or incorporated by or under a central act, a provincial act, or a state act. Now, we have been formulated by a state act and includes any such institution as may, in consultation with the university concerned, be recognized by the Commission in accordance with the regulations made in this behalf under this act. That's all. That is all that 2F is talking about. It is talking about what a university is. Naturally, if I am a law university, I will have to take affiliation from Bar Council of India. Naturally, if I am a university, I will have to be recognized by the UGC before I can start even functioning a single day. That does not change the nature and function which is being performed by me. I may be imparting an educational function, yes, but am I financially, functionally, and administratively governed by the state government? Your Lordships are aware, my learned friend is talking about Andi Mukta. The law has moved much ahead from Andi Mukta. We have seen Lawrence, Balmer, Lorry and company, where this actual test was laid down of these three: financial control, functional control, and administrative control. Further, in the Ajay Hasia case, your Lordships may perhaps recall that instrumentalities of state are subject to constitutional obligations, no doubt about it. Yes, but whether I am an instrumentality of state, how do you find that? There, you have to fall back on how I have been constituted. I am neither financially controlled by the government, nor am I functionally controlled by the government, nor am I administratively controlled by the government. It's a completely private university. Now, even for the sake of argument, if I say that, yes, it is a university, it is imparting education. Now, education is certainly a public function, no doubt about it. And had it been an educational dispute, your Lordships may perhaps recall Mr. Nila Datto at one point of time had argued a case about the Delhi public school guardians and what's this thing. And yes, those were public duties performed by a private institute. But where
students as a whole,
correct,
maybe affecting the society at large, then
exactly,
it becomes
it comes in public domain. So your Lordships will perhaps to see what is the nature of the dispute which is sought to be brought before your Lordships. If I may just place two Supreme Court decision before your lordship, or if my learned
No,
friend want-
let her complete.
let her finish.
We were just trying to find out that judgment Abdul Ghafoor Mandal.
Lordships.
That had discussed TMFI and many other judgments. Abdul Ghafoor Mandal ultimately had held, if I am correct, that these kind of relationships,
Right.
where a private institution, where what we call the non-government educational institutions,
Correct.
if they do something which to their teachers, if it's a service dispute, then perhaps it is not the victim. Then it is a tribunal which is provided for in the number one. Number two, if there are certain government act or rules or some provisions made by the government and those have been flouted, it is then the writ court would come in to have those required to be done. But if it is done within the institution itself, then would this lie? Because what we are emphasizing on is we are not disagreeing to it. Yes, there are public discharge of duties. Yes, Royal Global University being a private university would be at times amenable to the writ jurisdiction. We are not on that. Subject matter.
Subject.
Do we need to look into that? The students who have been, whom you are saying in your letter would suffer, no grievance from them. Had there been one grievance from them, it would have been an other way to look at it.
Your lordships are giving her ideas.
No. Then again, anything where the society at large or someone who's actually agreed, you were terminated. There will be other avenues of law. Writ, how does it come in? Not.
Lord, I want to read out a little brief. It is the first judgment compilation, page 31. This is a note from the case of K. Krishnamacharyalu versus Sri Venkateshwara Hindu College of Engineering. Is it there in this? The first compilation.
That is the whole thing. Your page 31.
Page 31. But this is also there in the written submission.
Immediately after page 30.
Right.
This is UK Yadav and JMA Industries. Unfortunately, the next page is blank.
It's okay, let's have the compilation.
It's all right.
It is a Monday. Today is a Monday. And if you go on searching like this, it will be
Let's
difficult.
get to the table, which
Which
also has this table, which is again in the written submissions. Number
Page
6.
29. Yes,
Yes.
yes. You got a table, page 29.
Right. So, K. Krishnamacharyalu versus the Venkateshwara Hindu College of Engineering.
Yes.
Right. Now, this case, my lord, was regarding the pay scale. It was a writ petition filed by teachers regarding parity in pay scale on the strength of executive instructions issued by the government, where under employees of private college were entitled to pay scale at par with the government employees. The Supreme Court upheld it and a writ was allowed. Now, the question that is put to us regarding one, of course, about the larger public impact.
Oh, in that case, perhaps it was equal pay for equal work and all that.
Yes, it was. And also, the private universities are not separated from the pay scale for teachers that's prescribed by the UGC. Now, UGC Regulation 19 is something that we're directly talking about. In fact, there's a table in the written submissions only at page number 35, in which we have made sort of a flow chart to show the kind of violation that UGC this situation seems to be having. Where we are speaking about. Now, we are talking about UGC Regulation 11.4. Now, my learned respondent repeatedly talks about Article 12, but forgets to contrast it with 226, where the question of being a public authority comes in. Now, when there are such direct and gaping gaps in the PhD supervision, where the PhD, right on the face of it, we do not ordinarily require a student to come and say that my PhD is under threat, because they would have gotten a supervisor. But the question that appears here is whether this whole process of PhD happened as per the UGC Act, which is a statutory law. And also Delhi Public School and school tribunals are very different from a PhD supervisor's case. Because a PhD supervisor is directly appointed through the UGC Act and PhD regulations. In fact, even a non-teaching staff from the college can be a PhD supervisor if they fulfill the requirements of the PhD requirements of UGC. So the larger public concern here is a private university is openly defined the not just the position of law of UGC Statutory Act, but also taking away copyright not just from the professors but also their students, and students are able to get PhDs in such arbitrary manner where one doesn't know who has given them what kind of requirement. So when we are talking about public authority, if my lord wants
Sent to impress the court, you would not be making grievances. We would not appreciate your reference to that kind of.
My lord, at this point, the petition is only allegation. I have half a counter affidavit. I have shown my cards. If the other side doesn't show me the cards, I don't know.
Because why should I respond to the statements
Nothing
which are
good
in
or
the
bad.
law?
I'm just saying, nothing good or
First,
bad.
no, Lordship,
Nothing good or bad. I'm just saying. I'm
first
saying
and foremost, this honorable court has to decide whether your lordships would want to interfere in the matter or not. If not, the debate ends there. And if yes, then I will be given a chance to file my counter. That is the normal process when a preliminary objection is raised.
It's nothing good or bad, ma'am.
It's not matter of good or
I'm just saying. I'm just saying that right now, all I can give is allegation. I will be able to substantiate this further when I have a counter and when I'm able to address the court. on that.
You have to convince us thoroughly that the action taken by the university while discharging you from service and taking your students away from you, placing them under someone else, was something in the line of a public discharge of public duty.
Right. So first,
Now, if we have to go a very long way to reach that conclusion, the exercise of discretion may suffer. And we have given you 2 cases which fell out of we spoke out, and some resistance from them, of course, that I'm giving you ideas, but even then, that is taken in a humble way.
So tomorrow she'll bring a PhD scholar and place before your lordship
I
and have
wish
your
I had
objection.
that kind of clout, but I don't. I can
No,
assure
no,
you.
I did not go.
That's not
Nothing,
out of
nothing.
I know that's far I enjoy it.
Yes, yeah. So what we do is go through the 2 judgments that we have said, the TMFI judgment, which actually speaks of what is the extent of discharge of public duty by educational institutions, which part of it falls under public discharge of duty and where can the courts interfere. In fact, the Supreme Court went ahead to hold that there should be educational tribunals for a reason. Writ courts were taken, the extended decision from writ courts were almost taken away. Following that judgment, the Assam government had to train for private institutions an educational tribunal. Now, we are not saying that you need to go to an educational tribunal, but we are saying that there is a logic behind what this High Court did sitting in a full bench. Why it was held that it will not be the High Court at the first instance. There was some logic behind it. Then her affidavit in opposition contains 2 or 3 judgments. Some reply to that. What the judgments you have referred to us, you are trying to say it is a state. In certain cases, yes. We need no further argument on it. Certain discharge of duty, yes. We need no further arguments on that. This was the thing done, and this is a public discharge of duty. That is what we need. We'll have to cut it short. It's a
So, see the cases, we have responded to the cases that they have provided in their response.
by arguments or by saying that, no, this will not be applicable to the present case at all.
The applicability of those judgments to the present case are quite scant. The reason being, they are primarily talking about service contracts. And they're talking about contracts in private
If your case is
organizations.
that your
not
students
suitable.
are, if your case is that your intellectual property is being, would be harmed, Your rights to intellectual property, this is not the forum.
That's one of the factors.
Secondly, your students may be at a loss, not for this forum at this stage.
But then the discharge
Your-
termination without so called notice, charge sheet or anything as per.
Anything and
regulations.
everything that you would require, would it fall under, unless you fall under that particular category where we can interfere?
But that is the
Anything done by a public authority, we would not come in.
But that is the category, that is the special category I hold because I'm a PhD supervisor. I am not, I mean.
I don't think that termination order has said so.
The
That we are taking away your,
termination doesn't say anything.
that would be a fallout of your termination. Where is your termination order?
The termination is there. It's also there in the written submissions. It's
No, let us have it at the
Page
repetition
60.
itself, easier for us.
Page 67 of the writ petition notice. book. Annexure 9.
Your appointment letter?
Annexure A, P1 44.
It's 40. Running page 69. The important says that I will be subject to leave uniform and all other policies that are implemented by UGC and other statutory bodies now. And now if you see the language of the termination letter, that says that open defiance and various other allegations of misconduct and argumentative conduct, etc. And that's when.
Once we decide to interfere, then we will have to look into whether the termination was correct or not. Appears unceremonious, but the correctness or otherwise of it would be taken up only once you can convince us that this termination, this appointment, engagement given in the year 2022, 30th of June 2023, you are on probation. Since you are allowed to continue, we do not know whether you have a confirmation or not, but this termination on these grounds, was it in the discharge of public duty?
Right. About
More specific on that.
whether two professors get a discharge of assume a discharge of public duty, and whether there is a public.
No, every person in a teaching institute is doing something for the society. The moment he is removed, somewhere it affects. But is it enough?
No, is it enough in the sense
Ah.
while I'm teaching or doing my job at a public authority, which is a private university, I'm discharging a public duty under UGC Act. The duty flows from the UGC Act, right? Now, when I'm being terminated for whatever misconduct it is, the UGC Act tells me that I have to get a notice, charge sheet, hearing, show cause, and all those elaborate procedures, and then disciplinary committee. In fact, one of the cases they quote had 3 disciplinary committees. It was a CBSE matter, but what happened? The disciplinary committee gave framed their charges. There were arguments, everything, and finally the court said that one needs to go to the CBSE for an appeal because that's an appeal.
Okay, we will fix it on a hearing day with very little number of cases where we can devote. You come from outstation or you are?
Come from Delhi and Chennai.
Delhi and Chennai. Any convenient date, we'll take it up on a hearing date, we'll decide this issue first.
Like, can we do this on Monday?
Next Monday. Monday is not a hearing date. Tuesday or Thursday should be.
10th, if you want. You're okay.
10th?
Yeah, I'm okay with that.
Okay. Yes, 10th should.
Subject to your lordship's.
10th,
10th.
we have got 8 cases fixed. 10th of April. Of course. Huh?
Seventeenth.
17th is good.
Lordship, 17th is a little inconvenient for me. I am out of station. Lordship. Then it will have to go to either 19th or 24th, your lordship.
24th.
24th.
In that case, can I have it in the first week of March?
Yes.
First week of March, your lordship, we don't have any dates today.
Oh. Second and third and second week, third and
Yes,
fourth.
third and fourth are
There are
they're closed
for
for holidays.
10th.
10th.
10th of
10th.
I have a.
Yes, 10th of March. Yes.
10th
10th of February, your lordship, we'll try and 10th of February.
10th
Yes.
of February.
10th of February. No, no, 10th of February fixed. क्या chat करना? क्यों नहीं लिखा है?
And also just, I wanted to clarify about not having UGC as a party. Firstly, the court can impede them whenever they want, and second, it is also a fact that UGC's directions are to be implemented by the university. So first, the university has to respond, and we can only impede other parties when we have a response from them. If you see the first case where,
there is a term, says that the petitioner is the master of his own case. You choose whom and whom not to.
definitely, and till now we stand by not.
There are
using
ways
UGC.
and
But you are
Allegations
the-
against UGC, Ma'am.
Yes,
We
but
have no allegations against UGC.
we'll just find out. There are also respondents who are not always against you. If you say more.
We will implement them by the next hearing, we will implement them. I'll take the idea from ma'am.
no more
This is the
pleadings.
matter again on the 10th of February.
10th of February.
On which date the preliminary issue as regards the maintainability of the road petition will be taken up for decision. We'll do it.
Fine.
We'll decide it.
Okay. Deeply obliged. Deeply obliged.
I am retaining a copy of this regulations that we have taken, this UGC
Yes,
part.
of course, sure. Of course, of course. It is not a complete one. I had only given whatever was necessary.
Only the relevant portion is there?
Yes, yes. Deeply obliged.
But then we should also probably supply you the UGC regulations because our relevant
should also
portion is
make
there.
UGC a party in that case.
Please.
And we'll make UGC a party, yes.
Yes, madam.
Yes, Lordship, he instructed me that they have no objection in disposing the petition, directing the petitioner to
Deposit the.
deposit the compensation money. But there is some procedures as regards he has already served the state for some years. That procedure they will follow.
No, I don't understand. Here it is by the regulation which is here, your gazette notification which is here, madam.
Yeah, Lordship.
It says that if you want to leave, you will pay 25 lakhs and leave.
Yes, Lordship.
So he could have done it day one also by giving you a 25 lakhs.
Lordship.
Now the number of years to serve, not serve, that will not come in.
That will not.
You want a quietus to the matter, you want a disposal of the matter? We can grant him a week's time to tender his 25 lakhs to you or approach you before that, asking you what are the relevant documents he needs to do.
Yes.
Give him a list, he'll produce those things, take the money, appoint someone in his
Yes.
place,
Lordship.
let people be served.
Lordship.
Is it not? Now you don't have anybody there because he is holding the post, you have not terminated him. He is having a very good life in Hojai.
Hmm.
We are having a tough time in Guwahati.
Yes.
Why? Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Ms. So-and-so learned counsel appearing for the respondent health department, full stop.
D board.
The learned counsel for the petitioner has submitted that the petitioner is ready to deposit the rupees 25 lakhs as required under the agreement executed by him and also as required under the Council, this is for the next cases that will come from your table. This kind of documents we will not appreciate. Writ petitions will be dismissed only because documents are not legible.
Notification.
Yes, this is the notification you want us to read. This is the way it is published by the in the Assam Gazette. Is it? Not in this manner. It will be in a cleaner, much better manner. This is someone sent you a WhatsApp, you've got a printout of it. What is this? What is the name of this rules? Page 24, what is it?
Assam Medical College, bracketed.
See? Bracketed and write down. Assam Medical College bracketed A of admission, yes.
Admission of post-graduate.
No, it is regulation of admission. When you can't read it.
Medical College Rule 2006.
Not done. Assam Medical College Regulation of Admission of Postgraduate Course, bracket close, Rules 2006. Full stop. The Learned Counsel for the respondent was required to take instructions on the same. And this court has been informed that certain procedure and documents are required to be submitted before the resignation, along with the money can be accepted. Full stop. The petitioner shall approach the, yes, which authority should he go to, madam?
Yes, Lordship.
Which authority should he go to?
Go to
whom?
Health and Family Welfare Department, A
To
department.
the respondent number 5, that is
Five.
the Director of Health Services, Hengrabadi Health Complex, Hengrabadi Road, on, give us a date, madam?
Also to respondent number 2, Lordship.
Please respond our whole mail.
No,
Director of Medical
Director of Medical Education, also respondent number 2, Lordship.
Shall approach before the respondent number 4, that is the Director of Medical Education, 6 Mile Khanapara, Guwahati 781022,
Yes.
which authority has been stated by the counsel for the respondents and the petitioner to be the authority who would be in a position to direct, to guide the petitioner regarding the requirements for acceptance of his resignation and for submission of the amount required under the relevant provision of law. When? He shall appear before when? Give us a date.
Lordship.
When should he appear? When should he appear before the DME?
As your Lordship, please. After
20th
a
of
week or
on 20 of, no, make it on 10th of February 2026. Full stop. On the appearance of the petitioner before the concerned authority, the authority shall guide him regarding the further proceedings to be undertaken. Full stop. The petitioner may complete the formalities on or before 27th of February 2026. List this matter again on 5th of March 2026 for further consideration. None appears for the petitioner on call. The earlier occasion also none had appeared. Fixed by Mr. Arbor Pujari, Learned Counsel has appeared on both the calls today. Full stop. The matter is of 2018. Full stop. The writ petition is dismissed for non-prosecution on 2 consecutive occasions. Yes, sir.
Lord, as per direction of this honorable court, on 12 December,
Ah.
my lord, the instructions have been, my lord, incorporated in an affidavit, my lord, that has been filed today. The matter has become infructuous in a sense. Since the entire CPF amount amounting to rupees 8 lakh, my lord, has been withdrawn way back in 2023. While the proceeding was
Pending.
Yes.
Lordship, I could not take instruction because petitioner is hospitalized, Lordship. Petitioner is hospitalized, so I could not take instruction, Lordship. I received the copy of affidavit 12:30 today. Lordship, provide me some time so that he can provide me some.
That is why we did not allow them the time in the morning.
Lordship. And provide me to file affidavit rejoinder, otherwise
How much time? He is in hospital, how much time?
after 2 weeks, Lordship.
Learned Counsel appealing for the Guwahati University has submitted that the affidavit in opposition has been filed with a copy being supplied to the counsel for the petitioner. A stand has been taken by the Guwahati University that after filing of the writ petition, the petitioner has withdrawn the entire CPF money. Full stop. Learned Counsel for the petitioner submitted that the petitioner, she could not obtain instructions on today itself because the petitioner is stated to be undergoing medical treatment and is hospitalized. Full stop. Let's this matter again after 2 weeks as a part, again on. Who's the date, madam?
Containing to your Lordship. After 2 weeks, Lordship.
18th of February.
18th of
18th of February 2026, by which time the petitioner may, yes.
20th, Lordship.
20th of February 2026, by which time the petitioner may file a rejoinder affidavit to the
Affidavit in
affidavit in opposition file and further also have instructions as to whether the petitioner desires to continue with the litigation since the CPF money has been withdrawn. We say that because once he is withdrawn, if it is for medical treatment, it is spent, he will have to give it back if he wants to get a pension.
Lord, it's not affidavit in opposition, additional affidavit.
Did you file an affidavit in opposition earlier?
Yes.
Oh, let's file an additional affidavit. Yes.
Most of it.
Yes, outcome is there.
My lord.
Any outcome?
No, outcome is
similar
not, my
matter?
lord, that agitation is going on regarding that person were, my lord, from regular service to they were, my lord, then to tutored. My lord, from regular service, my lord, they were, my lord.
Did you go through the order dated 23/5/2025? Learned Counsel for the petitioner submits that order DNA. Learned Counsel for the petitioner submits that a similar matter has been heard by a different bench.
My lord, that exactly not similar. I have gone through, my lord, that, my lord, that.
It's a different matter.
Yes.
Yes.
Something different, my lord. Something my different.
Prepared? Yes. We'll take it up for disposal.
My lord, I want to file rejoinder because, my lord, and I will go through that judgment, my lord. Because, my lord, that was, my lord, I have
How much time do you
reverted
need?
regular
How much
petition.
time do you need?
2 weeks only.
Mr. C. Goswami, Learned Counsel for the petitioner has submitted that he will require 2 weeks to file a rejoinder affidavit. The affidavit in opposition was filed on 22/10/2025 and on 23/5/2025, a submission was made that a similar matter had been heard by a different bench and the outcome of which was awaited. Full stop. Though this court is reluctant, as an final opportunity, the petitioners are given an accommodation of 2 weeks up to 16th of February 2026 to file the rejoinder affidavit. Full stop. It is made clear that on next date fixed, the matter shall be taken up for a matter and the matters would be heard on the basis of the pleadings available on record as on that date. Put it on record, will be no further extension should be granted on the ground of filing of proceedings or for bringing records. 16. To Ankedas Poli. Ankedas Poli, BTC. Yes, sir, 16, we will take it up and dispose it.
My lord. Otherwise also, my lord, they have not given the full benefit, my lord. From 15, they are not giving, anyone was not given benefit because when in anticipation of approval of finance, my lord, that appointment was done. But I am converted to tutor, right? There is no, yes, some person brought to regular performance without.
We'll see what we can do on.
That's
25.
My lord, Respondent number 6 filed affidavit opposition. I also filed reply. But I have challenged the appointment order of Respondent number 9. My lord, he has appeared, but no affidavit has been filed.
All the good, all the better for you.
My lord. And affidavit is required, my lord.
No, he has nothing to say on your allegations.
Nothing to compensate happened.
It has got nothing to.
And his
Oh,
younger brother has getting appointment, lordship.
so remove him and consider him. Remove him, consider him if he is not filing an affidavit. You are appearing for whom, madam?
Nine.
And he has not filed the affidavit. And you have nothing to say. You are taking away your job, giving it to him. What do you have to say? What do you have to say? Have you gone through the file? Yes. What did you find in the file? You will be able to know. What did you file in the file? 2 weeks. To do what? No. What did you understand in the case is what we are asking, madam. You have to speak up someday. Speak up today. This is what your brother is saying, that you've got the job by committing fraud. What do you have to say on that? Whether it was a fraud, whether it was not a fraud? Has the man given you any instruction? Have you gone through what he has written? When will you tell us? Tell us a bit. You have filed an affidavit in opposition, have you seen? Have you gone through that affidavit in opposition? You must have attended moot court. No. No debate till today. What does he say in the affidavit in opposition, respondent number 9?
Respondent number 6, my lord.
Who is 9?
Respondent number 6, my lord. Respondent number 6 filed affidavit. my lord.
We have filed.
I also filed reply, but respondent number 9 has not filed affidavit.
Respondent number 9 has, who is respondent number 9? What is his name?
Private respondent, Saifuddin.
Name.
Saifuddin.
Matter of affidavit in opposition filed by the respondent number 9 in WPC number 2T28 of 2022.
My lord, as per report, my lord, the respondent number 6.
Dear. It must have file contempt, dear. 5 minutes of episode not up. Go to the affidavit in opposition. You may lose your job. Although not today, but you may eventually lose your job. Go to the affidavit. We'll ask you what is there in the affidavit. Read the. This is item 28. Yes, sir.
Kindly say order dated 12/12/25.
26, 27 key will. Regularization. Yes.
Kindly say order dated 12/12/28.
Lordship, it's under consideration, Sir Lordship, but 2 weeks more time may be granted, Your Lordship.
So after 2 weeks, who comes with the report? Who comes here with the outcome? Some officer has to bring it here.
Yes, Your Lordship.
Who will bring it? We'll take it out after 10 minutes. There is a instruction of 22/5/2025. a hearing was taken by the director.
I have already taken a telephonic instructions, Your Lordship, in the morning. So they have instructed me to take it for a 2 weeks more time, Your Lordship,
what?
for the papers work to be done, Your Lordship. For the papers work to be done for the Lordship.
From 22/5/2025, you have done nothing. Hearing was scheduled on 4/6. When do you want it? When? Because of
Instructed me to take 2 weeks time, Your Lordship.
2 weeks. It should be second, 19th. 19th?
Okay, Your Lordship.
19th? Miss H. Kerampi, Learned Council appearing for the Secondary Education Department has submitted that a period of 2 weeks accommodation is required to bring on record the outcome of the hearing which was conducted on 4/6/2025 at 11 AM as per the earlier instructions dated 22/5/2025. Full stop. It is noticed that by an earlier order dated 12/12/2025, the time was sought to place the outcome of the action undertaken by the respondent authorities. Full stop. Place the matter again on 19, on which date the respondent authorities shall ensure submission of the outcome of the hearing. And if the hearing has not been concluded, the details of the authorities or officers who did not cooperate for expeditious conclusion of the hearing. Tell us who is not cooperating. It is a DO, BO, DI. Tell us. You heard this matter, no?
Yes, madam. That Malad dispute, that the petitioners and the Malad private respondent both are language teacher, madam, and petitioner is a senior. He has been appointed in the year 1995 and the petitioner is.
Yes, Mr. Sharma.
Lordship, the first thing, first thing is that Lordship, I'm not a language teacher.
You are what?
At the time of appointment,
You are what?
at the time of appointment, I was a subject teacher, and thereafter I have been promoted as a headmaster by the managing committee.
So you were never an English teacher, language teacher.
Lordship,
You were never an language teacher.
Lordship, language, Lordship, since the English is not a English is not considered. Yes, sir, Lordship.
You say that you are not a language teacher.
I was not a language teacher.
Next.
Lordship, for a moment, your Lordship may kindly come to page number 24. I will start from the page number 24. Page number 24 is the Lordship UDISC Lordship, that was at the time of Lordship registration of the school, Lordship. The number of teachers and the headmaster that has been Lordship stated here, Lordship. I was recorded as a Lordship headmaster of the school. Your Lordship will find at page number 24. 24 of the writ petition.
What is the date of this document?
It was the document, Lordship.
Where is the date of this document?
26 October 2019, Lordship. As per the Lordship, page number 25, the time and print that was recorded, Lordship. It was only the
printout timing.
Printout timing, Lordship.
Printout timing date can be anywhere.
And now, page number 25 is the Lordship, the writ petitioner.
Yes.
Lordship. The writ
In service since
1/1/1990.
Lordship.
And your page is in? Your name is where?
Lordship, my name is Sujya Bhattakur.
Where is it?
Had page number 25, 24, column number 3, Lordship.
Huh?
Column 3, Lordship. head of the school.
So where is your detail? When did you join?
Lordship, my joining, your Lordship will find at page number 27, that was enclosed by the writ petitioner. Page number 27, 6/5/2002.
This is manipulated.
Not, I'm not saying Lordship, this is manipulated.
This was given by the petitioner.
Lordship?
This is a document which the petitioner has
Yes,
produced,
yes, he has enclosed, Lordship.
which is signed by you.
Lordship, it was submitted.
Was it signed by you? Was it signed by you?
Yes, sir, Lordship. Yes, it was signed, Lordship. Signature is there, Lordship. Signature is there, Lordship.
So your date of joining the school is 6/5/2002
2000.
and his date of joining is 11/95.
95. That is true, Lordship. Now your Lordship may kindly come to the appointment of the petitioner. That your Lordship, private respondent, Lordship, your Lordship will find at page number 28.
Yes.
Your Lordship will find, in pursuance to the Gov. Order so and so, and in accordance with the provision contained in the Assam Educational Provincialization Service of Teacher and Reorganization of Educational Institution Act 2017, Governor of Assam is pleased to provincialize the service of the following person of recognized UPS as tutor. Tutor signs with effect from 1st January 2021 as per the terms and conditions given below. Your Lordship will find he has been appointed as a tutor. And so far the section 2, subsection U, your Lordship will find that headmaster can be appointed. There is no bar to appoint headmaster as a tutor, Lordship. Because headmaster can also be appointed as a tutor. And now your Lordship will find what speaks by the Lordship section 3, subsection 1, XI. Your Lordship will find.
So Sharma, you have filed your affidavit. Cost of paid for cost.
Lordship, here only one thing.
You will hear you. Modak will hear you. For non-cooperation with the pending matter, given the opportunity. What is the page number?
Lordship,
311.
3-1, subsection 111. Lordship.
Page number?
Lordship, I have taken the printed copy of the act, Lordship. May I read, Lordship? In case of Bhansar Upper Primary School, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics and social studies and language, and C is language. Provided that for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009. Lordship, as per the rule, the maximum teacher that can be appointed at initially, Lordship, that is 3. One is, Lordship, the science and mathematics teacher, and the second is social studies teacher, and the third is language teacher. And if your Lordship will go by the para 13 of the writ petition, your Lordship will find that, Lordship, para 13, may I read, Lordship, page number 10. That the petitioner begs to state that the decision of the DSC for recommendation of headmaster as social science and Hindi as a language cannot be tenable at law and is against the relevant provision. The 2017 Act does provides for such recommendation and same is illegally, arbitrarily and malified. If the respondent number 6 was provincialized, then the practitioner service has to be provincialized as a regular teacher. His claim is only to be appointed as a Lordship regular teacher. In fact, Lordship, if I have been appointed, I being a headmaster, and initially since I was appointed as a social study as a subject teacher, I can taught each and every subject except the maths and science is if I did not possess a degree of Lordship, BSc in Royal Science, as it is a criteria for maths and science teacher. Language teacher, on the other hand, it has been mentioned in the impugned order that the respondent number 6 is English teacher, but the respondent number 6 is the junior of the petitioner and service of the petitioner is entitled to provincialization. The petitioner claim provincialization on the ground of seniority, but the respondent number 1 in the impugned order have not discussed anything about seniority and upheld the illegality provincialization of the respondent number 6 without any just cause or reason. Reason sustained.
Pairwise, we can do that any time of the day you want, by taking out the battery from the clock.
Let's see, I will let's see.
You are not his senior.
Yes, sir.
Admittedly.
Yes.
Do you for once, can you for once say that seniority will not have any role to play in the provincialization of services? Seniors are not to be given the scope.
No, Lordship, I am not saying. Only my submission before this honorable court is that there was an interpretation of the honorable court.
You are a counsel. You have a right to say.
Yes, sir. Lordship.
Sitting on this side, we have a right to ask.
Yes, sir.
So let us ask.
Yes,
first.
yes, your Lordship.
The order which is challenging simply says DLSC did not recommend his name, therefore finished.
Yes.
Right?
Yes.
The DLSC does not say that why his name is not being recommended.
Yes.
That his seniority had been taken into account.
Yes.
Nothing of the sort. There has been no controversy from the state respondents. We are not deciding whether you are eligible or not.
Yes.
We are deciding whether he is first to be considered or not. In case he does not make the provincialization, then you come in, he being a senior. Let us say he is not from language, he is not science, he is not social studies. Yes. So first he will be removed. That you do not fit in the criteria. Who is the next one? Respondent number 6. He fits everywhere. And he gets the provincialization. Not getting my point.
Yes,
Now taking up your case and putting you in the considering only you without referring to him, when you admit that he is your senior, does it not require an interference of the court?
required.
It requires. To what extent?
Only my
To what extent? Setting aside of the DLSC recommendation
yes, sir.
and all consequential orders therein.
Lordship, only my
And it will go back to the DLSC
yes, sir.
with a big zero. We will not tell who is where. They will take up this particular page 27 again. Do the entire exercise.
Only my humble submission before this honorable court is that once a person has been appointed, subsequently one more person has been charged by the authority because that person was at that time was not eligible. That was the that was on the face of the record. I have already
Is
submitted.
it?
Yes,
So
your
what,
Lordship.
what record? I
Yes.
don't understand.
Your Lordship will find at
Oh.
page number 65 of my affidavit in opposition filed by the Lordship respondent number 6.
Does it say?
Because at that time I have been appointed, Lordship.
Please see.
Column 26, the school was established in 1995. It is situated in the Assam Yes. Area, the condition of the school big is semi.
It is your document, sir. It is your document you have given in the affidavit in opposition.
Yes, Lordship.
You are not being able to read it. I'm sorry, the court is unable to read it.
Lordship,
We will not read illegible copies, sorry.
Lordship, here, Lordship,
Yes, let the
relevant part is,
party-
the relevant part is very clear, Lordship. The Hindi teacher and Prafulla Kolita and Hindi teacher Jiban Jyoti Kotoki are underqualified.
So what happens to underqualified teachers who are being considered for provincialization? They come in as tutors. Yes. Underqualification is no excuse. Next.
And therefore, they have advised to Lordship engage the qualified teacher at that time in the year 2005, Lordship. When
Very good.
at that time I was found as a qualified teacher, Lordship.
We'll note this.
Yes, Your Lordship. But
Yes.
only my last part of submission before this honorable court is that there was an observation that was made by this honorable court in the case of Lordship Dimbesar Gogoi. Lordship, the honorable court has categorically discussed the provision of section 3, subsection 1(11). Lordship, since there is
What will be there? Who
Lordship,
would be there?
Lordship,
Saying what will be there? There will be only three teachers.
three
One
teachers.
this, one this, one that.
Yes.
Only the three?
Yes. In this case, Lordship, since I have been appointed, I have been appointed as a Lordship tutor. There was no mention in the order, appointment order that Lordship, I have been appointed as a
What tutor?
what tutor. Yes. And the second thing is, Lordship, that it has been clarified by the, when representation was submitted by the petitioner before the authority, and that subsequently they have specified that I have been appointed as a Lordship English teacher. And though it was recommended as a Lordship for the subject of social studies. And since only one post has been filled up, and remaining 2 posts are still laying vacant for appointment of the Lordship petitioner, it is open to the respondent Lordship to appoint the petitioner as a language teacher, because it has not been disputed by anyone to appoint as a claiming as a language teacher in that school, Lordship.
Done?
That's it.
Mr. Sharma? This court in earlier occasion had recorded that respondents have not filed their affidavit in opposition. Prior to that, on 5/8/2025, affidavit in opposition. 26/2025, lost. No affidavit in opposition. 22/6/2025, last opportunity to file affidavit in opposition. 17/2. So we'll take this matter up at the end of the list, since he has got very long elaborate arguments to make. We'll take it up at the end of the list. We'll get our judgment today itself. We'll take it. If required beyond 4 hours, because we cannot spend time in listening. We'll take it up at the end of the board. We'll dictate the judgment today.
I have only 2 things to submit, Lordship.
Yes.
On the last occasion, your Lordship directed me to obtain instruction as to on what basis the petitioners that order improved was passed.
You have the reports.
Only I have a written instruction I have received today. There is no dispute as regards the date of joining, because the private petitioner is senior to the respondent. The only and the subject taught was also the respondent was teaching English earlier. But by virtue of a resolution passed by the district level authority, the recommendation was made on social studies. This was the resolution.
Giving no.
Being a headmaster.
Giving no importance to the date of appointment.
Lordship.
Or what subject he was teaching.
Lordship, this is the resolution.
It is not even discussed there.
No, nothing.
Oh,
It is not discussed, Lordship. Only that last paragraph, it has been shown. But
Discharge of public
as
duties.
regards the date of joining and subject taught, there is no dispute.
Which one? Prostab number tini?
Prostab number 3.
Tini?
I think the bottom one.
যোৰহাট শিক্ষিতপ্ৰাপ্ত সকলো মাধ্যমিক শিক্ষাৰ্থীসকলক সমাজ বিদ্যাৰ শিক্ষক হিচাপে প্ৰতিষ্ঠা They are not taking into account any service record.
Lordship, that is
Whoever is a head teacher, just forward them as for provincialization as social studies teachers.
So this is
Who are the members? Only two of them.
members are there at the page number 2. There are the members present. These are the members. Page number 2. Your lordship will find there are 8 members.
Yes. End of the board at Ulom for dictation. Yes, Mr. Kukan. Who appears for the secondary education?
Here, Lordship, here the treasury officer has said that there is no PPO issued. So for if my learned friend is asking for the family pension, Lordship, that has to be, the treasury officer may have received an application.
Secondary education has called that deal. It has to come from
Yes,
the department.
Lordship, yes, Lordship.
Initiated by the department, then it goes to the AG.
Yes, Director of Pension Investment.
Director of pension, the director of pension will give the PPO and it reaches
Yes.
you and you get the pay.
So if,
Have you found out from the petitioner whether she has deposited all the documents or not?
My lord, we have
All the
deposited, my lord,
documents
and it was forwarded to the pension department by the treasury officer.
So the
Then treasury, pension department and sent back, my lord.
Lordship,
Thereafter,
here
madam-
I'm, maybe an application for family pension, maybe the
There-
petitioner might have filed it. So it was
you have to
forward.
file the application for family pension to the concerned department, sir,
Lordship, because my lord,
not to the treasury officer. The word is very good, treasure. He has got a lot of treasure, but he cannot disburse it.
family pension, my lord, during the, my lord, lifetime of my father, my lord. Then in 2018, my lord, rule has been changed.
To do what?
Amended that the unmarried dependent daughters will be eligible.
We understand that.
Lordship.
Now the family pension that you are supposed to get for whatever rules, that
Lordship.
application has to go to whom?
Then, my lord, the school authority, my lord, forwarded to treasury. Treasury
I
forwarded.
made a mistake, but you
So,
submitted
my
it
lord,
to
you
the
lost,
school.
lord.
When can you submit it to the concerned actual director's office? You tell us that, or the DEO's office. Elementary or secondary?
Elementary, my lord.
Elementary.
So you
to the
lost
DEO's
call
office.
for the elementary education department to make instruction on the last day. my lord.
Yes.
Tell you, scanning council elementary education directions to.
But no copy has been provided, my lord, to us, my lord. Persona number 9 file affidavit, my lord, without serving the copy, my lord. Only received the, my lord, pending council, my lord.
Oh.
I am being a petitioner, my lord.
Yesterday also we said it, saved by the hair of the teeth. No, skin of the teeth, skin of the, huh? Saved by the skin of the teeth. Miss so-and-so, what is your name?
M. Begum.
M. Begum, learned counsel appearing for the respondent number 9.
Lord,
Undertakes to serve a copy of the affidavit in opposition filed before this court on 8th of April 2024 to the learned counsel appearing for the petitioner within
As well as, my lord, government.
within a period of, tell us, madam,
allow us
Only-
2 weeks time, my lord,
to file.
to file our affidavit.
Only fine, my lord.
Sorry to.
The learned counsel appearing for the petitioner and to the learned counsel appearing for the respondent, other state respondent. Learned Government Advocate Assam. This matter again on 12th of February 2026, on which date Ms. Begum, learned counsel appearing for the petitioner, shall inform this court whether the copies have been signed and the contentions which are taken up in the affidavit. The affidavit is already filed. Search of the copies, give them copies, and on 12th, tell us what is the stand of the respondent number 9. You will have to tell us.
I also filed my lord affidavit in reply against the affidavit opposition filed by the respondent number 6. Against the affidavit opposition filed by the.
Check the record. If it is not there, go and have it corrected.
It is not on record, my
Go and correct it there. We will not correct it. You are short staff to help each council. You have to do it yourself.
Oblige.
Yes.
Your Lordship had begged in the morning to adjourn it for the day, and then can it be taken up with item WPC 4736 of 2025?
There are similar matters pending where a senior advocate Dipankar Nath is appearing in such matters, Lordship. So what I pray,
At the request of the learned council, appearing for the petitioner, which is not objected to by the learned council, appearing for the respondents, list this matter along with WPC number
4736
47
of 2025.
of 25. ঠিক সব নাই হ্যাঁ হিটু রিপিটিশন আর লাগবে তো হিটু রিপিটিশন ডেট ফিক্স নাকি বলুন এখন তালাকাটা দেখিয়ে দিবি সেইখনই আলাদা না এইখনটা আলাদা করে
Lordship, can you see page 29?
Yes, there was something, some papers relating to release of salary as per the petition is under process.
Yes, then therefore we have placed the report before the finance department. Finance department, Lordship, instruction.
How many objections?
Lordship.
How many objections by the finance?
One objection.
One objection. Who was the authority who sent it without without meeting the objection? Why was a half-baked cake sent?
This case, your Lordship will have to, I think, direct it to page 29.
Have a look at this.
No, they have been doing it. with revenue
Sir.
department, they requested to obtain the views of the judicial department. That has been going on for last.
Come for 4 lines from below. Sentence starts with that. 4 lines from below. That since there appears to be a court case involved in the instant queue. Now that is why the proposals will be rejected, sir. Who appears for revenue and DM department?
Department, I am appearing.
Who appears for the personnel department? Yes, sir. They have sent you a proposal that we want to use. Show him the. No round games.
Unknown game is going on since 2017.
No, we will put a stop to that.
2017.
Please read the instruction.
This is the second round.
Yes, when can this deputy secretary appear before the court?
Before that, also may I get the.
He will appear before the court.
Let me get the updated instruction from.
He will
because I
appear
was-
before the court on 19th of February unless
Unless I for this updated instruction. Yes.
he will appear on 19th at 2 o'clock unless you fail to have the instructions at 10 o'clock on 19th.
100%.
I will not give 1 day time.
But they are not giving because finances, their prior approval was not given by the council.
Now the instruction is otherwise. The instruction which has come says the case is already approved by Essence.
Yes.
The only issue is, since there is a court case, please take legal views.
No, that is there, but already my lord, page 71 is there. 23.
It says,
My lord, finance, main thing is that this is the only hurdles.
page 70?
71 one.
Page 71, who is it? Yes.
This is what it says.
Yes,
2023.
Mr. Chalia.
2023, it says the reason for concurrence is that the approval of the finance department was not obtained prior to his appointment.
Yes.
This is the only reason.
That is the stand taken by the finance department.
Can it be solved out?
Lordship,
Can it be solved out?
now Lordship
They
here,
are asking for a post facto approval, ex post
Yes,
facto approval.
yes.
What
Regarding
is an ex post facto approval? I forget.
The prior
The pri-
approval,
prior, yes, Lordship from
before
a,
the appointment, they are depending on.
What does it, what does the term ex post facto approval mean?
Lordship, the post will be given a retrospective effect, Lordship, of post, yes,
I have done it.
Lordship,
I have done it correctly, sir.
Lordship,
I should have taken your permission, sir. I did not take your permission, sir.
yes, Lordship,
Please approve it now, sir.
yes,
Post facto,
Lordship,
ex post facto, already done.
Lordship,
What does your finance people say? You did not take it then. I
Yes,
will
sir.
not give it now.
yes, Lordship, yes,
Give a reason why the ex post facto cannot be given.
yes,
Give
Lordship,
a reason which is reasonable enough. The term says post facto, after the fact has taken place, please approve.
yes,
You make a statement in the court.
Lordship,
Then the department says, yes, we will abide by it. What have they done? They have given you a post facto approval.
Lordship. Lordship,
In this particular case, no, you did it without asking us. So we will not give you the approval. Can that be the ground?
yes, no, Lordship, that
Then-
is the, no, Lordship, here, that is the fact of the case,
Ah,
Lordship.
ah.
So now if Lordship reflects it in the order and gives us
Do
1
what?
week time to consider whether it, otherwise on the next day Lordship will
See,
follow the order. Lordship,
advices which should be coming from you to the department, we are incorporating in orders and sending it back.
Lordship,
We can't even ask for what we wanted to ask.
Lordship. Lordship, here, that is the,
We're not happy, Mr. Chaudhary. We are
Yes.
not happy. The finance, when they take up the actual good grounds, when they try to stop the flow of finance going up in wrong processes, appreciated, always appreciated by this.
Lordship. Yes, Lordship, the Lordship, I also, Lordship, fairly,
You have to consider whether everything was correctly done.
Lordship,
If it is done, the post is there, no one else is appointed, it is lying vacant, it is for compassionate appointment, and a person without any objection from any angle has been appointed there.
Lordship,
Okay, approved salary.
Lordship,
That is all it is.
yes, Lordship.
Oh, you didn't ask us. So, no one
Yes,
tells us in the morning, we will not do the case in
That
the
is-
afternoon.
Lordship, yes. No, Lordship, that is stand, and now they're saying, we are asking the airing officer, take action
Yes,
against
sir.
the airing
To
officer.
do what? Oh, the one who said, I will not give the post facto approval.
No,
That
no,
person
Lordship.
or the one who appointed?
No, the one who appointed without the prior,
Do that, but what about the hunger of this man?
yes, Lordship, that,
Process server, madam.
Take all steps you want to
Lordship,
have it against, but not against it.
Lordship.
And sir, when does your deputy secretary come to the court to say that when there is a case pending, the case has been, the department has been allowed to process the file? He wants judicial views. When can he come with his, to hear our views on the issue? Free country, we can have views. Place this matter again on 11th of February 2026, by which time Mr. Choliha shall have complete instructions in the matter, since it is noticed by the court that the ex post facto approval was regretted. Now, the inability to give ex post facto approval was regretted only because prior approval was not granted.
The petitioner is responsible. No, I'm just giving one judgment, my lord, when
We are disposing it upon the next.
Lordship, Lordship,
the attempt for disposal.
With a continuing maintenance.
Lordship, yes, Lordship may pass the direction, then,
Mr. So-and-so, Learned Counsel,
Direct,
CKS Bora.
go from the court.
Huh?
Otherwise, you're not doing.
Mr. CKS Bora, Learned Counsel, preparing for the land administration, for the revenue and disaster management department, land administration and acquisition branch, Assam Secretariat, Civil, Dispute. We'll have appropriate instructions as to why the matter is not being processed in the proper manner, and also as to why, when earlier submissions had been made that the papers relating to the release of salary in respect of the writ petitioner were already being processed, now the matter has been sought to be referred to another interdepartmental communication only on the ground that the writ petition is pending. In case the appropriate instructions are not made available to this court, the concerned officer who put up the note on 212026 shall remain present before this court on the 11th of February 2026 at 2 p.m.
Finance will also bring information.
Yes,
That is the first thing we said. That is the
That
first thing.
judgment I have provided.
The learned senior counsel, Mr. Bidi Das, appearing for the petitioner, has submitted a judgment reported as 2024-11 SCC 770. Full stop. The learned counsel for the respondents to take note of the same. The matter will be taken up for disposal on 11th of February 2026.
Diploma.
Please.
As per instruction, that should be provisional pension is already released, but the other benefit to the GPS, GIS,
This was a case where what happened?
that is, the
Proposed notice.
that is the during the
There was a
suspension
DP.
period, during the suspension period, the petitioner is retired, and DP is always now is continuing.
What is the DP?
DP is with the
Where is the charge? Where is the charge sheet?
tax sheet. I
Proposed notice
proposed notice, is 30,
is 30.
37.
Even
37 is suspension order, and show post 43.
Where is the proposed notice, sir?
Show post 43.
What about the police case?
Police case now actually now appearance.
So now you will only get a provisional pension.
But the as per notification is
What more? Huh?
as per notification is page 55.
As per
Notification
which notification, sir?
55.
Page 55. Huh? You have got your provisional pension.
Lordship, to the other benefit, Lordship,
Where is the other benefit?
GPH and GIS, Lordship.
Where is it? No notification on that.
Lordship, only the DCR is.
Why not, how much time for release of the GIS and the
No, Lordship,
leave salary?
other than provisional pension, Lordship, the petitioner is, however, is not entitled to DCRG or
No DCRG. DCRG,
or other retirement benefit while
where is
the,
it given?
while the DP is pending.
No, where is it put?
Page number 60 of the affidavit.
60.
60 of the affidavit.
Show us the notification on which you are saying, sir.
Copy of some.
Let us hold it
I think
this way, sir.
annexure two.
Annexure?
Because copy of the, yes, the,
Notification.
no, it's a rules, Lordship.
Rules, yes, first. Pension code, yes.
Because it has been attached here, right?
Show us that one sentence. Yes. What is the GIS, sir? Mr. Borua, what do you mean by the GIS? What is GIS? What is GIS meaning?
gratuity.
What do you mean by the
Yes, yeah.
leave salary?
Leave salary is basically, Lordship, Lordship, leave salary is basically, Lordship, Lordship, that,
We will help.
you were saying, yeah,
We will help.
the absence, Lordship, that
We will just help you. GIS is group insurance scheme.
scheme, Lordship.
So it's an insurance which you took during service.
Lordship.
Can you withhold it? No. What is leave salary? He served you for 20 years, 30 years, 40 years. Every year he is entitled to earn leave.
Lordship.
Is he? Once he is entitled to earn leave and he does not utilize that earn leave, what happens? It gets added up.
It's together,
Up to a limit of what?
that
law? 300 days in his
300 days.
entire service period. He did not utilize the leave. So whose salary is it? It is
This is salary.
his salary. Can you withhold it? No. Now, listen to us. Listen to us.
Yes, sir.
You come to papers. You have had papers. You did not know the full form, so don't look at the papers. Look at us. Death, come, retirement, gratuity. What is gratuity? Thank you, sir. You have served us. We are grateful. Gratitude. This much of money from us to you. Correct? Rule says he is facing a disciplinary proceeding. He is facing a police case. Don't be grateful. Don't give it to him. So you will hold back the gratuity. You will hold back the DCRC. But the GIS and the leave salary by the end of February has to be released to him. No other way out. We will not take the long cut. DCRG, we will specifically record in the order, need not be processed at this point of time till the criminal case and the disciplinary proceeding
pending.
are brought to their logical conclusions. Done?
Process.
Let us not keep it pending then.
Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. C.K.S. Bora learned counsel appearing for the
Respondent number 4, 5, and 6.
4, 5, and 6. Mr. So-and-so appears for 1 and 2. The case of the petitioner in this writ petition as reflected from records is that he had served the circle officer Boitamari Revenue Circle in the district of Bongaigaon. And he was arrested on 12/3/2024 in connection with ACB case number 21 of 2024 under section 7A of the PC Act 1988 based on an FIR dated 12/3/2024 in which it was alleged that the petitioner had demanded money when the informant in the FIR had come for correction of land records. Full stop. The petitioner was suspended with effect from 12/3/2024, pending drawal of departmental proceeding by an order dated 14/3/2024. The subsistence allowance for a period of 90 days was also directed to be released to the petitioner during the first 90 days of suspension. The petitioner was released on bail on 2/5/2024. Full stop. A show cause notice was issued to the petitioner on 10/5/2024, to which the petitioner replied on 17/5/2024. The proceedings against the petitioner was recorded as DP case number 1 of 2024. The petitioner states that he has been participating in the proceedings to the best of his ability. Full stop. The petitioner was also allowed to draw 75% of the monthly salary as subsistence allowance after the period of 90 days of his initial suspension was over, full stop. The petitioner retired from service on 31/1/2025, full stop. He thereafter preferred a representation for release of his professional pension, comma, and what else? If you have not asked for it, you will not get it.
Only in his query, is only asking for provisional pension. Only specific to provisional pension. And the completion of the DP. Page number 13 of the petition.
Page number
13 of the petition, the payer portion. Only the provisional pension. And the completion of the DP.
The petitioner made a representation on 24/2/2025, praying for release of the benefits, which today the counsel for the petitioner submits that should be benefits in accordance with law. When the petitioner was not paid his provisional pension and other retirement benefits, he approached this court with the following prayers. To up to page 13.
Page 13
number prayer. Today, the learned counsel appearing for the petitioner has submitted that the provisional pension is being paid to the petitioner. Full stop. Mr. Borua, learned counsel for the state, has also endorsed the same. Full stop. The counsel for the petitioner has, however, raised a grievance that the GIS and the GPF money has not been, the GIS and the leave salary money has not been paid to the petitioner, full stop, on a pointed query by this court. Though the learned state council had had attempted to draw attention to the relevant notification by which the DCRG can be held back till the disposal of the department proceeding and the criminal proceedings against the petitioner, nothing has been shown to this court, either by way of notification or by any provision of the pension rules, that the leave salary and the GIS amount can also be held back by the department. However, without expressing our mind on the release of such GIS and leave salary amount, leaving it open to the petitioner to raise it in an appropriate litigation, this petition is closed. Observing that the provisional pension of the petitioner should not be interfered with by the respondent authorities during the pendency of the criminal litigation or the departmental proceeding without following the due process of law, it shall be open for the petitioner to approach this court again in case the provisional pension is interfered without following the due process of law. So petition disposed of. Yes. Mr. Chaudhary wanted some time. What? To obtain instruction.
No, he has already filed his affidavit and I also filed my reply.
Okay. Also, is coming with the admission column of orders.
It has come in the admission.
Admission. Admission.
Admission.
Yes. What is the grievance?
The petitioner now in this present rate is seeking her promotion to the post of Superintendent of Taxes.
Yes, tell her, has she been considered for promotions?
Lordship, she has not been because there are eligibility condition. Number one, she has to pass out the departmental examination and the practical test. She has passed out the departmental examination in 2015-16. But the practical test, first attempt, she didn't pass out. Thereafter, she has not appeared.
Lordship, the reason behind this, Lordship, because I was not allowed any GST related work since it came in the year 2017.
petitioner has
When
been
you
subject to
failed,
several harassment.
when you did not appear in the examination at
Because I,
all.
the practical
is not a
examination,
grievance in
of
this-
that component is GST related work
Let
only.
us have it this way, sir. You are under an apprehension that you would not be considered for promotion because there was a penalty of censure. We will record his statement. That the penalty of censure is not standing in your way for being considered for promotions, but it is rather the absence of your qualifying the practical examinations. Since the grievance raised in the writ petition has been answered by the respondent satisfactorily to the court, therefore we will leave you the liberty to challenge the requirement of your passing a departmental examination for becoming eligible to the, for being considered for promotions. You can come back with the writ petition, raising whatever grounds you want. And that you are not
Lordship, that
given
is a
what therefore-
statutory requirement. Eligibility condition is the statutory requirement under the service rule.
So he will raise his grievance
I have raised the reverse in here only.
regarding the examination.
Yes, Lordship.
Wait.
And Lordship, I have also challenged the
No, tell us
penalty of
that-
censure.
no, tell us about the examination. Yes, have you regularized the suspension period?
Yes, Lordship, in terms of the Lordship, there is a, this is the second round of
Pending
litigation.
area salary released?
That not, but Lordship, he is confining only to the
No,
penalty.
para 18, prayer
No,
clause at 18.
Lordship, in the reply, he is confining it to the penalty.
Reply is the child. The father started the fight. Yes.
Lordship, because
What
of
about the
my-
salary for those days? Page
Lordship,
18.
that also I think, Lordship, he has received that information.
Then
I have
earned leave period,
Lordship, may kindly go to the Lordship order passed by the Honorable
what
Court.
kind of leave it will be?
In my reply, Lordship, I have annexed the order passed by the Honorable Court, Lordship, page 142.
142. Which page
This is the first
142?
one of, in my affidavit in reply, it is the serial page, continuation of it, page 142.
Ah. Area salary you are granted.
Some
Then?
of the prayers have been granted or either processed, but I have not got the salary, Lordship, as per my information.
ठीक है.
Now-
These, no, just tell me one thing. These prayers that you have made in the writ petition, they have already been granted by this court in the earlier round of litigation. Okay.
This is
We'll
the
hold
timely-
you to that. You did not file an appeal? We'll hold you to that.
Lordship, with regard to the process, that till that I knew it, whether he has not received, that I have to
So
clarify.
what we will say is that there is already an order from this court granting him the most of the reliefs, other reliefs.
Yes, sir.
We will hold you responsible for that order. To bring all processes to an end within a period of the next 3 months. Whatever was allowed by the other earlier writ petition.
If not already. paid.
Then you don't have to do it. Is it?
Yes.
Yes, anymore? Anything more?
My Lordship, the present challenge is Lordship with regard to the order of penalty. Lordship, who-
Censure.
that-
Have you challenged the penalty?
Lordship, I have challenged.
Where is it? Set aside the order of penalties where?
Lordship, my first prayer, a writ in the nature of certiorari or any other appropriate writ, order or direction shall not be issued towards setting aside and crossing the impending order of
Where
penalty.
is the penalty order?
Penalty order, you know, will find that page,
Annexure E.
page 67 was.
Huh?
Page 67 of my writ.
Minor penalty.
Minor penalty. And Lordship, the inquiry officer does not found anything. I was, Lordship, the petitioner could not join the transport force immediately because of her Lordship uterus cyst, Lordship. She was suffering from uterus cyst and she was profoundly bleeding, Lordship.
Where is the inquiry officer's report?
Yes. Page 45 to 54, Lordship. The page 54, the confusion part. Page 51, Lordship, the fact document.
Yes, sir, we are sitting
Conclusion and
aside.
recommendation.
We are sitting aside the censure.
Lordship, may kindly look at page 51.
Yes.
Whatever the charge was there, based on the hearing held and documents submitted, it can be concluded that the charges leveled against so-and-so are established. It amounts to proving, it has been proved, Lordship. Thereafter, even though the inquiry officer is not required to recommend anything, but she has, due to her conduct, repeated transfer order, she doesn't want to
Only
join.
transfer only in.
Lordship, on the basis of her conduct, the disciplinary authority has imposed the minor penalty of censure.
And Lordship, before imposing the penalty of censure, Lordship, I have not been put in notice, Lordship, in writing. That is the mandatory. That is Lordship necessary as per Rule 9, Lordship. Assam Self-Defense Disciplinary Control.
Since when is that necessary?
It is amended, Lordship.
To ask you before the
And some
penalty.
judgments are also there, Lordship.
No, to ask you before the penalty. Sir, I want to give you this penalty. Something like
No,
that.
no, no. Lordship, because this is a penalty order also. I need to be put to notice, Lordship.
Of what?
That you are going to be imposed in the regard with the penalty of censure. You may have filed a representation against the penalty of.
Choice?
Lordship, law point has been decided by the honorable court, Lordship.
When?
Lordship, in Rabindranath Kolta Superintendent Engineering versus State of Assam.
When?
In Lordship 2013. The decision is with 2016. And another judgment, Lordship, of 2018.
The disciplinary authority shall frame definitive charges. Government for preparing his defense, disciplinary authority can nominate any person. Record of inquiry shall record of.
Lordship, may I please say?
Record is finding, then minor penalty. Near the should be imposed except for.
Okay, one small paragraph. In so far imposition of penalty of censure is concerned, the government servant would have to be put on notice by the disciplinary authority at the threshold that on the basis of the allegation, the disciplinary authority proposes to impose the penalty of censure and to seek his response. That was not done.
We'll keep it hanging till the time they give you a notice and then they decide. Now it will be a major penalty. Let me tell you. Is it not? I will set aside that censure. I would ask them to give you a notice on the nature of penalty to be imposed. Unauthorized leave.
And Lordship,
Is it not? Listen to us. Unauthorized leave.
no, unauthorized, Lordship, I have unlived, Lordship.
You have all the unleave in the world. What is unauthorized leave? It is not unavailable leave. The term is not unavailable leave. The term is?
Lordship.
The term is?
May I just?
Lordship, the regularization of all her leave will have an impact.
You want to bring on record whether the payment has been made or not? Learned Counsel appearing for the respondents has submitted before this court that an accommodation will be granted to find out, to inform the court as to whether the salary, earned leave salary, area salary, etc., and other benefits as recorded in the order dated 19/9/2025 in WPC 2044/2024 have been yet granted to the petitioner or not. The Learned Counsel for the petitioner would have his instructions as to whether in the teeth of the submission made by the Learned Counsel for the respondents that the petitioner would not be hampered by the recording of the censure only in case she fulfills all other conditions required to be eligible to be considered for promotion, this petition is required to be adjudicated upon. List the matter again on, choose a date, please. 11th of February 2026. See, so I've told you the order which if it comes, would open the gate for them to revisit it. I cannot say it is wrong. It will be revisited.
But I have sufficient number of.
Whatever is the inquiry report, I'll have to give them the liberty to reconsider it after giving notice to you. Is it not? It is a two-edged sword. Cutting that side, cutting this side. Unless you are very sure.
And Lordship, with regard to Lordship, I was not allowed any wrong related to GST. That is
Not
why.
a ground here.
Otherwise, Lordship.
Not a ground here.
Lordship, this petitioner, Lordship, I have taken the ground, Lordship. This petitioner, Lordship, all along, Lordship, she was the first, gold medalist. Why she could not pass the departmental examination? Only because of the.
You have till 11th of February to bring on record the appropriate. arguments that you would like to do. Yes, this is item 69. You are appearing in 69? In 67, kindly record it. Item 69? Tell us.
Similar matter is pending before this honorable court. And the same is WPC number
Please, this
927
matter along with WPC number
927/23.
23, which is stated to be pending before this
This
court
honorable.
by the learned counsel for the petitioner. Learned counsel appearing for the response. No object to this.
For the office of the AG, my lord.
Mr. B. Sharma, learned counsel appearing for the accountant general.
That's
does
one number 4.
Object to the said submission. It's not please accordingly. We are-
I
that-
have no role to play in that.
You have a role to play. You have the main role.
Yes.
Hello. Is the lordship, this matter may come up for hearing only.
2014.
Yes, lordship.
It also.
Engaged counsel is also out of station.
Huh? Huh?
Engaged counsel is also out of station, lordship. So matter will come for you.
When will he be available?
Lordship next week, lordship.
Next week.
Sir.
Thirteenth of February, at the request of the learned counsel for the petition of Mr. is made clear that further adjournments may not be entertained.
I'm for respond number 6 and 7, Lord.
Responsive episode, respondent number 6 and 7. And like.
Well, I am respondent number 3, Lordship. May I please.
Lordship, this petition was filed by the R12 SPCL. Now SPCL is no more. It is under liquidator. So the liquidator has instructed my lord yesterday to go through the matter. We want some time, my lord. Otherwise, I have gone through the record, my lord. So this is challenging the order of the tribunal.
You are required to pay some. Yes.
It was without wages.
Mr. Swinson and the council appears for the petitioner. On instructions received from the official liquidator, since the corporation has now undergone, is undergoing a liquidation process. Full stop. Mr. Swinson and the council appeals for.
Respondent number 3.
In case, it is provided that in case the petitioners, in case the repetition is required to be proceeded with, in view of, in the view of the official liquidator, arrangements for complying with the order dated. What does it say? With the order dated 19/11/2025 of the Lower Court. The arrangements may be made to take fresh steps on the respondent number 4 to speed post with AD. Full stop. In case the matter does not relate to the procedure further,
I will inform. I will inform the
learned counsel appearing on behalf on instructions of the official liquidator shall make a mention of the same before this court within a period of 10 days. Tell us within 10 days whether we need to proceed or not.
I have to take out the certified copy of all the documents, my lord. So it may 50 days.
Within the next 2 weeks. Within the next 2 weeks, we stop. If no such mention is made, it will be deemed that the matter needs an adjudication.
Deeply.
This is a case followed where 2017 judgment has yet to comply with. 2017.
There was another matter of yours fixed in the list. If you are the correct person, I don't know.
I have no idea. In fact, one aspect of the matter is that the council who she was selected for the APP, so interested me. So I had to also go through it, but
Where is
fact
the order?
remains there is a
You are appealing
urgency.
for whom? No, tell us what is the order which was required to be done, complied.
The appointment, of course, was pursuant to the court's direction.
Who needs to appoint?
Now, there is a speaking order passed by the respondent, whereupon, it is says that the concerned DC, that is DC Kukuraja is the appointing authority, being the appointing authority, he has to issue the order. Now, I have come across a document which the DC has disclosed that she was not entitled, the DC concern is not entitled to appoint the petitioner because SLEC was from. Well, it is an order of 2017. Now, recently that
So the
statement was
DC is trying to go round and round.
My lord, as per, as
violation of the clear violation, my lord.
some public service preferential appointment rule 1999, my lord. As per that, my lord, government is the appointing authority, not DC. DC only, my lord. DC will keep the record only, my lord.
The speaking order, my lord, in fact, my lord, appearing
Can you
opposition,
tell
my
us,
lord.
can you tell us, sir, there was a question going in our mind. You'll have to answer us on the next date. See, this is an appointment, differential appointment to persons
My lord,
who have suffered something.
my lord, my lord, my lord. There was
Now, the law itself requires you to make an application. An application for appointment.
That is there, well.
For consideration for appointment.
father was
Thereafter, you will participate along with all the other people. And you will be given a preference.
preference.
Preference, the question of preference will come in when two people are standing on equal footing and vying for the same post. Can you show us anything on record that you have applied for a particular post? You were on the verge of selection. There was another person competing for you. You were not given the preference. That is all.
That is why initially my prayer for lots is a specific date, short date. Because I have also come across the brief today. my lord.
No, I'm telling you the question that will come
My lord.
is before we take up contempt proceedings against the respondents, you have to show us you applied, you participated, there was a selection process where you stood on an equal footing with some other candidate and a preference was required to be given.
I'll satisfy your lordship.
Once that is done,
My lord.
that preference is not given,
My lord.
by the next 2 weeks, we should have your appointment letter.
Can it be a specific date so that on a
Choose.
your lordship.
Choose, sir.
17, my lord.
At the request of Mr. UK Goswami, Learned Counsel, appearing for the petitioner, list this matter again on the 17th of February, by on which date the counsel for the petitioner shall inform this court the date of the application, the selection process, and the on the selection process in which the petitioner had participated, in order for the respondents to consider her for appointment in preference as per the requirements of the relevant act.
Ambulance.
Yep. Who has filed an wakalatnama here? Wakalatnama ka hai, sir? This is a contempt case of the year 2019. the following orders, no, is done. It is seen that in most of the orders, time has been sought for on behalf of the petitioner. And in other orders, none has appeared before this court to assist despite there being wakalatnama on record, full stop. In view of the this contempt case is therefore closed on non-prosecution. Full stop. A copy of this order be sent to the office of the Bar Council of Assam, etc. In view of the fact that despite filing wakalatnama in the matter, councils have take away his license. Oh, cut out the last part. In this case, contempt case is closed as non-pressed. Two, 3, and 5.
Yes, my lord.
You have taken steps? Huh?
I have not taken step, my lord, because my lord, I have failed to contact with the clients. And even I have issued notice, my lord. Part of that, my lord, notice was also not served.
What was the prayer of the petition?
My lord, petitioner's prayer was for granting the benefit of ERS scheme.
Of?
ERS scheme. They were the workers of Apple.
Of Apple? Oh.
And my lord.
And you have not been able to trace out the office despite it being in Rajgarh, and it is no longer in Rajgarh or at house number 24, Kubsonia, Byland number 2. No, Byland number 4. It has moved from there also.
And
Yes,
my lord,
we took some pain to try and trace out.
and my lord, one more thing is that, my lord. Because, my lord, on the very first day, my lord, that there is an observation that the tendency of this petition shall not be a bar to consider the pair. And my lord,
You are
if
repaying
they have been
Cooperative
some
Cooperative
benefits have been given, I don't, even I. don't-
Cooperative department, cannot you not tell us whether this society is actually
It's under
functioning?
liquidation, my lord.
It is under liquidation.
Now, the official liquidator has been appointed and he's the authority.
What
Otherwise,
is the address?
address, your lordship, I can give it to my friend.
Why did it take you 4 years to give it to him?
Lordship,
He's a friend, you meet him.
no, otherwise, lordship, liquidator has been appointed recently.
Very well, but at least some address where he can perhaps take some steps, or you want to close this up? Learned Counsel appearing for the petitioner has submitted that despite best efforts, he has failed to receive any instructions from the clients. Learned Counsel appearing for the cooperative society has informed that the company, that the corporation has some.
Assam
The
Police-
society has gone into liquidation. The society has gone under liquidation. Full stop. In view of the above, this petition is closed in the present stage. Since the petitioners have failed to provide any assistance to this court through their counsel. And full stop. However, liberty is granted to the petitioners to pray for revival of the petition by filing an appropriate application if the case if it is so required. The petition stands disposed of. No use keeping this on the file. Mediation?
Mediations could not yield any result, lordship.
Why?
Also, the matter we fix after 3 weeks, lordship.
What is the
I find
matter
my
about? What is the matter about?
Lordship, matter is regarding the petitioners who are the employee of the Assam State Minor Irrigation Department, lordship. And they, I mean, some of the petitioners were absorbed that
And
irrigation
some were not.
department, some were not.
They were given VRS, lordship.
Huh?
They were given VRS.
You were given VRS.
Lordship.
I mean, we are compelled to, I mean, take the.
And you want what? What do you want now?
Pension.
Pension,
Why
retirement.
not you- What is VRS?
Lordship, voluntary retirement scheme, lordship.
So once a person retires, what happens? Give him the retirement benefits.
Lordship, I have to take instruction.
It may not be pension, but it will be some retirement benefit.
Definitely.
What is
that-
it?
That will be lordship.
Mr. N. Upadhyay on the Learned Council appearing for the state respondents on the next date would inform this court as to what are the benefits which would be made available to the petitioners in case their VRS has been accepted. They have been accepted, na? Since they are.
Lordship,
Accepted.
as per the pleadings, Lordship, they informed us that they were compelled to take VRS, Lordship, and even
They should have challenged the VRS lawsuit that if they are compelled.
What have you asked for? Have you seen? Direct the respondents to release pensionary benefits by extending them regular pension under provision of Assam Service Pension Rules. You are not under the corporation law, right? Direct command to give them benefits, treating them to be regular pensioners. It cannot be. Corporation, if there is a question of absorption, there is another case pending where what is the date of absorption? What will be the date of the benefit? Mr. Gogoi was arguing that.
Lordship, they may come up with the instructions, Lordship, by way of filing an affidavit.
What did we say? Mr. Upadhyay, Council looking for the respondents.
I am for 1 and 2, Lordship. My friend
Shall inform this court in the next date fixed as to the benefits which the petitioners will be entitled on their
retirement.
on their
VRS.
on their application for VRS having been accepted, whether the said benefits have been released to them, and as to why.
If not paid.
As to why the benefits of a regular pension has not been given to the petitioners concerned. The instructions may be in the form of other instructions may also be brought on record in the form of an affidavit. Mr. R. Pujari shall also have his instruction on the matter ready on the bench.
4 weeks, Lord. 4 weeks.
4 weeks, Lord. Matter is of 2024. 4 weeks. 4 weeks. We said it. 4 weeks. They given over it. 6.
6th of March. Obliged, Lord.
More than 4 weeks.
Lord. Obliged, Lord.
Lordship, in this case, Lordship, I have a small submission before this honorable court.
Yes.
So for the, since the, this honorable court has considered the, whether the district selection committee has considered the criteria, seniority as a criteria for recommendation for the provincialization of the teacher of Bhansar School. And so for the section 6, section 4 of the act speaks the eligibility criteria of the eligibility criteria for the provincialization of the teacher of Bhansar School. And the section 4 of the rule clearly says that the eligibility criteria, Lordship, may I read, Lordship? For 1 minute, Lordship. Rule to, sub-rule 2, the teacher and the tutors to be provincialized under this act must have been working as a teacher in the concerned Bhansar educational institution that have been fully recognized up to the last and highest class required for such institution by the competent authority on or before.
Thank you. We'll take up your matter after this.
Yes.
Yeah. Next to be. Yeah.
Somehow, I don't know.
He looks distressed.
They filed a contempt against the PCCF. PCCF has done his part, my lords. His name was considered found eligible, sent for the,
Who has not been, who is not complying, sir? After this, what happens?
after this, it is under process by the government.
Government of what?
Government, my lord, in the forest department.
But who is the person concerned?
That call has to be taken by the secretary, my lords. My lord, government.
Learned Counsel appearing for the respondent number, respondent page.
Page 17, my lord, government already directed the PCCA to consider.
Ah,
Page
ah.
17 considered.
Let us see this way, sir. Government has asked the PCCF to consider.
My lord.
PCCF has considered, and he has forwarded the proposal that you have to get it.
My lord.
Moment he does that, he has complied with the order, PCCF. He has complied. Now it will go before the government for final orders. They are not passing the final order.
But my lord, a later source date, my lord, page 17. My lord, PCCA was directed.
The PCCF has done his bit, sir.
The letter was of
Where is the order? Where is the order?
Order
into-
lodged, you will
order
find
of
it,
which
page number.
violation is
Paragraph,
alleged?
paragraph 6, my lord, the page 12.
Page 12.
Huh?
Page
Page
12
12.
of the petition.
Cover case, my lord, by Upen Das. There, my lord, respondent admitting this is a cover case. Still, my lord, petitioner is in.
Yes, to whom has he sent it to? Get some better instruction.
Problem
The
is,
PCCF shall place the same before the constituted
placed.
verification committee.
yes, that committee he has
Placed.
placed. Yes, placed. Then
Okay,
he has found,
thereafter-
he has been found eligible.
The
Now,
committee
has done
shall
its part.
consider the claim of the petitioner.
Committee has done his part.
Then,
Then if found suitable,
if the petitioner is found eligible, consequent benefit shall be given to him within a period of 1 month.
there
Now,
is a,
consequential benefit who gives?
that has to be, that has to come from government because finance is also a party out.
Government would be the secretary to the
Secretary.
the order of which a violation has been alleged. Required the PCCA to place the case of the petitioner to the, before the verification committee. And once the verification committee found the claim of the petitioner to be eligible for payment of minimum wages, the said were required to be paid to him within a period of 1 month thereafter. Today, Mr. D. Gogoi, Learned Counsel, appearing for the
Sole
sole
respondent.
respondent headed in this complaint petition and submitted that the verification has been done to the PCCF. No, that the PCCF has ascertained that the verification has been done by the requisite committee and the matter has now been forwarded to the government for further necessary action. Therefore, it appears to be scope that the next step to be initiated is at the level of the secretary of the forest department. First, this court grants liberty to petitioner to place an order, place a certified copy of the order dated 2023. Order dated 11/9/2024 passed in WBC 2646 of 2023 before the office of the secretary.
It would be office of the commissioner secretary,
Officer of the commissioner and secretary,
environment and forest,
environment
and forest department.
and forest department, Dispur, Guwahati, Assam, along with a copy of this order to enable to bring the pendency of this litigation to the notice of the aforesaid authority, so that he will be enabled to carry out further necessary steps to ensure complete compliance of the orders of this court. Mr.
I shall hand over
Mr. D. Gogoi, you shall hand over what?
one copy of the
No.
statement.
He'll give a copy of the petition and this order. What should instructions go to him? Mr. D. Gogoi, Learned Counsel, appearing for the complainant, sole complainant, shall also be at liberty to bring the pendency of this case to the notice of the
My lords,
Commissioner and
I'll
Secretary
do the needful.
of the concerned department to enable early compliance of the, I'm just saying this is early compliance of the orders of the, yes, all accounts. Huh? List over. Yep. If I exceed the time and any council deems it fit to not to continue, inform the court master and go, we'll give a date. If anybody is here, we'll try to see what is the in. This is 84. Yes, sir.
Lordship, in this matter, I am the lead petitioner and they have filed one IA, Lordship. Here, we are the opposite party. We have filed our reply, Lordship.
In the event no objection is filed, have you filed your objection?
Yes, Lordship.
When?
Friday, last Friday, Lordship. It is on record, Lordship.
Who appears for the petitioner? None appears for the petitioner. All? Miss S. Yasmin?
Yes.
Appears for the opposite parties in this IA and has submitted that the affidavit in opposition which was filed is already on record. In the interest of justice, list again on.
Much obliged, Lordship.
Maybe. Lordship, as per law, Lordship, matter has been, service has been completed, Lordship. Matter may be posted, Lordship, for admission.
In view of the orders passed by the law.
I need 3 weeks time to file my affidavit.
In view of the orders passed by the law Zima court, service of notice upon the respondent number 5 and 6 is complete, full stop. Accordingly, list this matter again after 3 weeks principle on the 5th of March 2026, by which time the respondents shall ensure that the response to the written petition is brought on record. Full stop. It is made clear that not true.
It is.
Here, my lord, as per office note, dated 30/1/26.
Office note reflects that the notices have been issued for the respondent number 4 to 30 by speed post only on 31/2026. All those steps were taken earlier. When did you take steps?
Service report is awaited.
No, on 19/1/2026. The office note dated 31/2026 reflects that steps by speed post was issued upon respondent number 4 to 38 by memo dated 19/1/2016. Place this matter again after 3 weeks. List this matter again on 6th of March 2026. Service report. Yes.
Obliged.
But the instruction from the education department, my lord, regarding
Education department, yes.
regarding sending the
Family
proposal.
pension.
Lordship, here, Lordship, my instruction is that there is no proposal received from the, either from the petitioner or from anywhere, Lordship. My
To whom
instruction
is it required to be given?
in fact, Lordship, if your Lordship sees
Sir,
that,
tell us this thing. To whom should the petitioner go so that the proposal can be initiated? Just tell us it.
DIF school perhaps he has to,
DI of school.
DIF school, otherwise, Lordship, here he has approached the treasury officer and.
All wrong.
No, Lordship.
It is wrong. We'll dismiss his writ petition, allow him to file a fresh writ petition, praying for a relief to go to the DIF school and so that the family pension can be released within a period of 3 months, which we will allow on day 1 itself.
No, Lordship, perhaps,
It will not be good, no? So let him go and approach the DI now.
no, otherwise,
We'll take it up after 2 months.
Lordship. No,
Let him approach the DI. DI of schools with all relevant papers, file his application, DI will process it, send it to you, have your verification done, forward or reject it. Come back to us in 2 months. Tell us what. Will that do? He is supposed to get family pension.
Lordship, certainly. Here he has approached before the treasury officer. And the treasury officer in turn forwarded it to the director of pension. Again, the director of pension has written
Send it back to the treasury
to
officer.
the treasury officer. There is no any
So
communication.
now give us a solution to the problem.
Lordship, here perhaps he has to approach the DIF school,
What
maybe.
did I say 2 minutes ago? That is what we had said. We are not clear.
Yes, Lordship.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. P.N. Sharma learned counsel appearing for the respondent State Department, Education Department. The learned counsel for the department has submitted that till date, no proposal has been received by any of the officers of the Education Department regarding payment of family pension to the petitioner. Here in full stop. The learned counsel for the petitioner is given the liberty to approach the Deputy Inspector of Schools, comma, Kamrup, Metro or Kamrup? Huh? Yes, schools, comma, Kamrup, with all relevant documents by which a claim for family pension can be processed. On or before, tell us. You give us a date. It is your petition. When can she approach the DIF schools? Just tell us that.
Second. Within 10, my lord.
Within the 10th, on or before 10th of February 2026, on which date the aforesaid, on which date the Deputy Inspector of Schools shall peruse the documents being produced by the petitioner and advise her with regard to requirement of any other documents within a period of 7 days.
A list of documents they will provide, because
You have to go and ask. They will not send anybody to your home, I'm sorry. Advise her on any further documents that may be required for processing her claim, full stop. Upon all objections at the level of the DIF schools being met with by the petitioner, the matter shall be forwarded to the appropriate authorities for further processing. Full stop. List this matter again on. Give us a date.
After 4 weeks.
March or middle of the year. Oh, March or middle of the year. 18th of March 2026, on which date the petitioner shall submit before this court the steps taken by the petitioner with regard to the observations made in this order, and the understanding council shall also place before this court the stage of processing of the family pension of the petition. All right.
Okay.
Item 65, yes.
The action was given to respondent number 1. That instruction has to be short from the respondent number 1 or and then 2, 1 and 6, Lordship. But in the
Do you
order,
have that? You've taken 65?
but if I'm not wrong, the action has been given to the revenue department, Lordship. But actual instruction has to be come from them.
Somewhere I have written the
Instead of
instruction from the
65, Lordship.
item 65. What did I say? I asked the instruction from whom?
Directed to respondent revenue department to take
Revenue,
instruction. But the instruction has to be come from the respondent number 1, Lordship, personal department, Lordship.
You just make a mark of that. Write down the order. एकदम नीचे आप personal department लिख के रखिए.
ठीक है, so
I will see where we could put it up. Yes, all done. Hierarchical declaration. Another 5 minutes, huh? No, he was making a submission. I will take a note of it.
Okay.
Lordship, so for the
Section
Act
we have
is,
read.
Act is concerned,
Section we have
4,
read.
Lordship, Section 4 clearly says the eligibility criteria for provincialization of the service of a teacher of Bhansar school. Your Lordship will find subsection 1, the subject to fulfillment of all other provisions of this Act, the service of the teacher and tutor of all Bhansar educational institutions eligible under the section 3 shall be deemed to have been provincialized on the date of publication of the provincialization under order by notification in the official gazette, and they shall become employee of the state government with effect from such date.
We have read it, sir. Which part are you emphasizing on?
Lordship,
What, which part you are emphasizing on? We have read it.
Lordship, on the part of seniority. So for this,
It does not provide for seniority.
Lordship, because this rule does not provide the criteria.
Of seniority.
Is a criteria for provincialization.
Okay, seniority is not a criteria. Yes, anything else?
And only the criteria is that Lordship, must have been rendered 6 years continuous service as on 1/1/2017.
So at the whims and fancies of the DLSC, a junior may be sent up for the provincialization, while the senior most teacher would be asked to stay home because the rule
Lordship,
does not provide
this
for
rule-
senior.
No point of time, Lordship, this rule has not been challenged by anyone, Lordship.
Ah,
And there, when your Lordship will find when the case of the Lordship, allocation Roy and 62 others that was considered, and that that was in that case, Lordship, though the Hindi teachers, they are eligible, either they may be eligible because they have been appointed in the year 1983 till to 2010, and there in that cases, Lordship, the seniority and all other aspects that has not been considered. Only because of that as per the section 3 subsection 1, 11, 3 teachers, minimum 3 teachers that that can be provincialized under the act, and 1 additional post that can be created by the authorities.
Does this case say that seniority is not the criteria and cannot be resorted to? Seniority will not be taken into account is what this case says.
There was no such Lordship observation made.
Then why are you taking us for a ride? In a quiet range?
Only my why I am making this submission before this honorable court is
That
that
seniority should not be a consideration, cannot be the consideration.
one point, Lordship, since my appointment has not been directly challenged by the petitioner, because I have been appointed in a post of social science. Although it was earlier recommended as a social science teacher, and
Arguments heard? You can do.
and subsequently I have been appointed as a English teacher. Though my initial provincialization was only as a teacher without mentioning any post. And since another 2 posts is laying vacant, one is language teacher, that was the claim of the petitioner, and the second one is Lordship, science and mathematics teacher. That was also laying vacant, that no person has been considered for provincialization. In that case, if the petitioner will be appointed or will be considered as a language teacher, Lordship, then my Lordship, provincialization will not affect.
Were you recommended as a language teacher?
Lordship?
Were you recommended as a language teacher?
I have not been recommended as per the Lordship.
You have been recommended because আজি সভায় যোৰহাটৰ স্বীকৃতি প্ৰাপ্ত সকলো মধ্য ইংৰাজী
That
বিদ্যালয়ৰ
was not challenged. Lordship. I have not seen that one.
Oh, we will shut our eyes when something illegal comes
Because
to us.
he has not challenged that one. Lordship.
Is that the proposition of law? We will see something very grossly illegal and you will say, so sorry, sir, we did not.
No, I am not
That is
saying
to be-
Lordship. I am not saying Lordship, because that was not on the part of record. Only my assumption.
It is now.
Yeah. And
Astonishing that my lord.
and nothing has been stated by the petitioner regarding my alleging my appointment as a Lordship social studies teacher, Lordship, subject teacher. He has not made any
He has
evaluation in
challenged
the
the
petitioner.
order which has rejected his claim for provincialization. Now we'll keep it silent. We listen to you, now listen to us.
Yes, sir.
He has challenged his order which rejected his claim for provincialization. He has challenged it, we have gone through that order. That order simply reflects DLSC did not change, so we are not changing. That is not what was required to be done as per the earlier orders of the court. So his case will require a reconsideration. Once his case requires a reconsideration at the DLSC level, then the DLSC should redo the entire exercise again. Going by the finding that the respondent number 6, or is it 9?
Six, Lordship.
6 was recommended on a resolution saying that any and all head teachers will now become so-and-so teacher. That DLSC resolution has to go, consequentially everything has to fall. And a fresh resolution has now to be taken by the DLSC, taking everyone's service record into consideration and thereby making a recommendation in accordance with the provisions of the act which you have been so kind to elaborate us.
Yes, Your Lordship, it as per the section 6 of the, section 4 of the rule, if it will find, if the DSC will find appropriate, their earlier recommendation, or I may be found as a eligible candidate, then in that case, Lordship, all the consequential benefits and all.
Earlier, entire DLSC has to go because it was not based on service record and merely on the basis of whether there is a head teacher. That is not the ground given in the law, in the act. So that resolution was wrong. Everything following it has to go. Every provincialization perhaps made after that resolution has to go. We will not hold it to that action because others are not before us. You are.
All due
Yeah,
respect, my lord,
judgment,
all the-
Lordship,
only one
their
honorable
Lordship,
submission
this
person can be
honorable
given
court has.
a observation while my lord reconsidering, that should be strictly with the my lord existing law. So
Lordship,
that they cannot insert any my lord
Lordship,
documents.
Which are already, everybody's stand as per the affidavit will be taken into account while disposing the case.
Mine.
Only what was before the DLSC at that point of time is what will be taken into account without saying that all head teachers will become social studies. Such kind of a resolution is not permitted. Yes.
Lordship,
Reconsider
only
should be on the basis of the-
only on the basis of the Lordship, the judgment passed in the case of Dimbeswar Gogoi. There, this honorable court has observed that, Lordship, it is.
Compilation, underline it, kindly give it there, disposing, I am disposing it, whatever the consequences be.
Yes.
And whatever length of argument you would like.
Lordship, only that, that the Lordship.
There is a
observation
judgment of this court upheld by the division bench which says that seniority will be the consideration. Where is it? Don't do your work.
My lord,
We'll have to do your work.
my lord, next time, my lord, I will take
Next
care of it.
time. There is no next time in this.
No, my lord, in this case, I will.
There is no next time. There is no next date. When will you give it?
No, my lord,
After I have concluded the arguments, we will not take it into consideration.
definitely, I will, my lord, try my level best.